Okay, it is now 9 o'clock. Can everybody hear me?
Yes, Your Honor.
Okay, thank you, Mr. Felber. All right, let's go ahead and go on the record. Good morning. Today is October 10th, 2023, and the current time is 9 a.m. The commission has set aside this time today for day 2 of an evidentiary hearing in the matter of Brett Felber, complainant versus Union Electric Company doing business as Ameren, Missouri respondent, and that is file number EC-2023-0395. My name's John Clark. I'm the regulatory law judge presiding over this hearing today. Also with me today on the video conference are several of the commissioners. I know we have the chairman of the commission, Scott Roop, on right now, along with Commissioner Maida Coleman. Do I have any other commissioners at this moment? I don't hear it at this time, but I would imagine that other commissioners will be joining us from time to time. I'm going to ask at this time, since we have a new court reporter today, I'm going to go ahead and have the parties enter their appearance again for the record, starting with Mr. Felber. Mr. Felber, you are pro se, that is, you are representing yourself. Is that correct?
Yes, Your Honor.
And you don't have an attorney?
Correct.
And on behalf of Ameren, Missouri?
Kendall Banks Law, LLC, 1824 Shoto Avenue, St. Louis, Missouri, 63103.
And Ms. Grubbs, also on behalf of Ameren, Missouri?
Yes, good morning. Jermaine Grubbs, that's spelled G-R-U, B as in boy, S. And I am appearing on behalf of Ameren, Missouri. My business address is 1901 Shoto Avenue in St. Louis, Missouri, 63103. Thank you.
Thank you. And I'm going to note for the record at this time that we've also been joined by Commissioner Kayla Hahn. Proceeding on, Mr. Tebow, would you care to enter your appearance on behalf of staff?
Yes, Judge. Appearing on behalf of staff, Jeff Keeble. My address is 200 Madison Street, P.O. Box 360, Jefferson City, Missouri, 65102.
Thank you, Mr. Keeble. And do we have anyone present from the Office of the Public Counsel? I hear no one. I wasn't expecting anyone since nobody appeared from the Office of the Public Counsel last time, but I always ask. As I indicated before, this is day 2 of this evidentiary hearing. As much as I don't like to split witnesses in the middle of testimony because it was getting rather late on Friday, I did go ahead. Ameren has one witness in this case, and their witness, Aubrey Kirchmeyer. They were doing their, Mr. Banks was conducting direct of Ms. Kirchmeyer when we broke. I have for Ameren's witness in regards to who is going to be doing cross examination, order of cross, will be first Brett Felber and then the commission staff when we get to cross examination. I'm going to remind everybody, because we did have to go in camera on Friday for a substantial portion of the hearing, and that may be the case today. I don't see anyone on at this point who would not be entitled to view confidential information. So there would be no need at this point if we were to go into an in-camera session to do a breakout room, but depending on who's present, we might have to if we go in camera. Again, I will say, just for the simplicity of not putting confidential information out there unnecessarily, that if we are referring to the residence where the disconnection occurred, that we refer to it as the residence where the disconnection occurred, or alternatively as the fluorescent address. I will take breaks as is necessary. So if anybody needs a break at any point, let me know. And that goes for you as well, Ms. Hefner. If you need to take a break, please let me know. If I am mumbling or we are speaking too fast and you don't get something, please stop us and ask us to repeat. With that in mind, we may be playing some audio exhibits that can be from time to time difficult to hear.
Thank
Um,
you.
Judge, Commissioner Holzman's on.
Oh, thank you, Commissioner Holzman. We have just been joined, for the record, we've just been joined by Commissioner Holzman as well. So we have the chairman and I believe right now 3 additional commissioners. Okay, just out of an abundance of caution, I don't believe I need to, Ms. Kirchmeier, but I'm going to go ahead and swear you in again all the same. So you raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth? I'm sorry, I didn't hear you.
Yes, Judge.
Thank you. Mr. Banks, you may continue with your direct examination.
Thank you, Your Honor. Ms. Kirschmeyer, do you recall on Friday, October 6th, 2023, I think was the last question you were asked before we concluded for the day, when you explained that the company does not believe exhibits 8, 9, 10, and 11, the complainant's multiple versions of the pending payment agreement email, they were not accurate?
I do not believe they were, no.
Please, let's look at your response to staff data request 27. Exhibit 119C. Ameren, Missouri does not have a copy of the actual pending payment agreement confirmation email sent by Grid SendGrid. And Madam Court Reporter, that's spelled SEND, same word, GRID. So let me start over with my question, please. Ameren, Missouri does not have a copy of the actual pending payment agreement confirmation email sent by SendGrid to complainant's email address on May 18, 2023.
No, we do not.
We discussed previously that during the normal course of business, account contacts are added into the CSS.
Yes,
So what are you asserting in the bottom of page 1 of exhibit 119C is one of the account contacts related to May 18, 2023 pending payment agreement?
yes, that is a capture of the contact that was placed on the account when that pending payment agreement was established.
Did you listen to the call recording from May 18, 2023, when complainant called Ameren, Missouri customer service to set up the pending payment agreement?
Yes, I did.
And did you also listen to the cross of Mr. Felber?
Yes, I did.
Is the account note you inserted at the bottom of page 1 of exhibit 119C consistent with that recording?
Yes, it is.
At the top of page 2 of exhibit 119C, you set out the values that were inserted by the system into the email template.
Yes, I did.
So Ameren's, Missouri's record of what values were sent to SendGrid showed the due date for the $2,509 required payment to activate the payment agreement was due May 18, 2023.
Yes, it was.
Again, a due date for the $2,509 requirement payment listed there is consistent with the May 18, 2023 call recording.
Yes, it is.
And that's exhibit 104CD.
Yes,
The complainant identified the alleged email regarding the payment agreement as a basis for his informal complaint.
no,
Let's look at Exhibit 123C. Is this the informal complaint submitted by a complainant?
yes, it is.
Is it your understanding that Exhibit 123C is the complainant's informal complaint?
Yes, it is. And in the complaint description, it indicates that Brett stated he had a payment arrangement to pay $2,500 today, 5/19.
Your Honor, I move that Ameren, Missouri's Exhibit 123 be accepted into the record as evidence.
Any objections to Exhibit 123C, the confidential exhibit, be admitted onto the hearing record? That is the informal complaint.
I do not. I'll, in my cross-examination, I'll
Okay,
go
I
over.
hear no objections from staff, so 123C is admitted onto the hearing record. You may continue direct examination, Mr. Banks.
Thank you, Your Honor. And Your Honor, Christy Manning has her hand up.
Oh, I apologize. Let me see what that. Miss Manning, is there something that you wanted to address, or? If there is, you can shoot me an email, please. Thank you. All right, go on, Mr. Banks. Thank you for letting me know that.
Thank you, Your Honor. The complainant identified the alleged email regarding the pending payment agreement as a basis for his original formal complaint.
No,
What about the first amended complaint?
no,
The second amended complaint?
no,
So Ameren, Missouri's answer and affirmative defenses, Exhibit 124C, couldn't and does not respond to the alleged email due date discrepancy.
no,
Your Honor, I move that Ameren, Missouri's hearing Exhibit 124C be accepted into the record as evidence.
Any objection to admitting Exhibit 124C, Ameren, Missouri's answer and affirmative defenses, which was filed in EFIS in this case, onto the hearing record?
I have no objection.
I hear no objections. Exhibit 124C is admitted onto the hearing record. Please continue.
To your knowledge, when did complainant identify the alleged pending payment agreement email date discrepancy?
To the best of my recollection, it was approximately June 20th.
On page 2 of Ameren, Missouri's Exhibit 119C, you explain the senior software engineer also advised that if a customer downloaded the payment agreement confirmation email, they would have the ability to edit the message.
Yes, I did.
During the course of your job as a regulatory liaison and working on complaint cases, do you ever reach out to software engineers for information?
Yes, I do.
Have you personally downloaded a confirmation email and been able to edit the message?
Yes, I have. During the course of my investigation, I personally Well, I found out how easy it was to edit emails. I downloaded emails from my personal email box and was able to edit those not only from Ameren, but from other sources of email that I received. And I found that you don't even have to actually download the email in order to edit it. You can actually just forward an email and edit it. And it appears to be very authentic. So yes, during my personal investigation, I was able to do this.
Your Honor, I move that Ameren, Missouri's Exhibit 119C be accepted into the record as evidence.
Any objections to Exhibit 119C being admitted onto the hearing record?
I would object that for the best interest of Ameren, Missouri, that is Ms. Kirschmeyer just admitted that she's altering documents. She just admitted that she went into her email to find easy things to edit, and she was playing around with it. That would be a
agree
motion.
that she did. She did not indicated that she had edited any of the information in this exhibit. Do you have an objection to this particular exhibit?
I don't have any objection to the exhibit. No.
But yeah, I will agree that she indicated that she had taken some of her private emails and downloaded those and seen if she could manipulate them.
Which means she was actually going into a system to alter any document.
And I've got some questions about this, and I'm sure you do as well, but as for right now, we're just dealing with the admission of this document. Do you have any further objections to admitting this document onto the hearing record, Mr. Felber?
No, Your Honor.
I hear no other objections. Exhibit 119C will be admitted onto the hearing record, and you may continue your direct examination.
And Your Honor, if I'm not mistaken, I thought that you held ruling on complainants Exhibit 12.
I did, and I have that set aside. We're talking about the Twilo information.
Yes, Your Honor.
Would you like me to address that at this time?
Yes, Your Honor.
Mr. Felber, you had an Exhibit 12, which consisted, I believe, of 6 various things that you got from Twilo in regards to how one, depending on the different kinds of coding that are being done, I understand, enters values into the Twilo system. Is that correct?
Yes, Your Honor.
Yep.
And I had held admitting that since I felt it was a responsive exhibit and the information that it was responding to was not in the record yet until such time as the information that it was responding to was in the record. At this time, do you wish to offer again Exhibit 12 for admission onto the hearing record?
Sure. Yes, Your Honor.
Any objections to admitting Exhibit 12 onto the hearing record?
Yes, Your Honor, we certainly object as irrelevant. Twilio was not Ameren, Missouri's vendor, and this document provides no value.
What do you mean Twilo was not Ameren, Missouri's vendor?
Well, I'm assuming that Twilio, which is an organization I never heard of before, is the parent company of SendGrid.
Okay.
Yes, they are the parent company of SendGrid, and they actually help with templates and everything too. That's actually who, if you were to get a data request or if you were to want to get documents from, is where you would have to send in paperwork certified mail to.
Mr. Felber, this thing that Twilo sent you in regard to clients, is this the same template that one would put into SendGrid, or do you know? Can you establish that?
From what I gather out of everything, yes, it would be the same build. Just they're the parent company. Any official responsive information would come directly from them. The coding paperwork that was sent in, that even though it has SendGrid, it also has Twilio. It would bounce back in between both. The parent company holds all the server records of each account. From what I gather from what they said, they hold everything. So if there was a process where they were having a problem, they would have had to reach out to Twilio. Twilio would then go ahead and send all that information back, and that would be the template and everything, however they're designed. That's between them and Twilio.
Yeah,
Hold on just a second, Mr. Banks. Mr. Felber, I'm going to go ahead and swear you in because while you're not testifying right now, when I ask you things from quite time to time, those are kind of a hybrid situation and some of it borders on testimony. So since I swore Ms. Kirchmeier, and I'm going to go ahead and swear you in again, and then I've got a couple of clarifying questions for Ms. Kirchmeier. Mr. Felber, do you solemnly swear or affirm that the testimony you're about to give or that you give today at this evidentiary hearing is the truth?
Yes, Your Honor.
Okay. And Ms. Kirchmeier, I'm going to ask you a few clarifying questions that I was actually going to do later, but I think they are somewhat germane to this Exhibit 12. Have you used the system that kicks out these automated pending payment agreements yourself?
What system are you referring to? The actual, the SendGrid system?
Yes.
No, Your Honor. I do not have access to that.
Okay. Do the customer service representatives?
No, they do not.
Do you, did SendGrid, do you have like an Ameren specific build of the SendGrid software to enter information into?
From my understanding, yes. There information that we enter into, the information that is entered into our CSS customer service system, the billing system, is then uploaded via a secure method to SendGrid, which then, so we insert the values into the template, and then those values are then inserted into the alert confirmation courtesy email that is sent to the customer.
Now, when you say that there are values inserted in, are those values inserted into an Ameren program?
Yes, they are. So we actually have, it's called, internally, we refer to it as the DPA window. It's the Deferred Payment Agreement window. And that is the system that our advisors use when they are entering a pending payment agreement for a customer. So they enter in, it defaults to the payment due date. That is a default based on the collection activity of the particular account. So there was no manipulation or changing of the May 18th date. So at the date that the call was made, that was the only option for a due date for a pending payment agreement, since it was going to be in threat of disconnection the next day. So the only values, it auto-populates based on the coding that is entered for what a payment agreement offer should be. So therefore, there's no need for an advisor to manually figure anything. The system already figures it based on the balance of the account and the arrears, and whether we're a non-cold weather rule or cold weather rule, since there are different rules for the payment agreements. So that information is automatically defaulted into this DPA window. So basically the advisor is basically will, once they've had the discussion with the customer as to whether or not they agree to the terms of this pending agreement, they just have to hit a button, and the values are automatically sent to our vendor for that courtesy alert email. That contact is automatically generated, which I included a snip of in my data request response about the payment agreement. So it takes away any risk of manual calculations that are in error. So the system automatically does all of that for the advisor. So then at that point, their only responsibility is to clearly share those details with the customer to make sure that they understand, what they are agreeing to.
Okay. I'm going to ask a few follow-up questions. So what, in regard to a pending payment agreement, what information does the customer service representative actually have to input into, and I'm assuming that they're not doing any coding.
Correct.
What do they have to put into to populate a field? What information do they actually have to enter, and what information is automatically entered?
Well, for the most part, ideally, there is not any information that the advisor has to enter because all of the fields will populate to the options. However, there are times when a customer may want to make more of a down payment than what the system is requiring. And they may want to, so it will auto-populate to the maximum. The maximum number of installments, the minimum payment needed. However, there is the advisor has the opportunity to adjust those fields if the customer says, perhaps in this instance, maybe the customer said, well, I can actually afford to pay $3,000 down. And I would really prefer for my installments to be 6 months instead of 12. So there is the advisor has the ability to change those installments if needed, if based on the conversation with the customer, wants to do something different than what they are eligible for. But in this case, there would not have been any need for any changing of the values because, what the advisor quoted Mr. Felber, which was the 2509 and some change needed today with 12 installments of 210, that is what was already populated in that window.
Well, let me ask a couple questions because we went over on Friday with Exhibit 102C. I think it was 102. I had some questions. No, actually, I believe it was a different exhibit. It was in regard to the payment agreements. There was a payment agreement on the end that had indicated that there was no down payment required, like a 0 down payment.
Correct.
So would that be an example of a case where a field might automatically populate, but that a customer service representative could change it?
Correct. Yes, Judge.
The customer service representative change that date, if they so chose.
The date cannot be changed. The date is a field that is not able to be changed. So, for example, if I'm just speaking hypothetically, if an advisor has an option when they're discussing the payment options available to a customer, if, for example, the disconnect date, the minimum payment date is October 15th, and the customer says, well, I really want to pay that today. The conversation would be such that the advisor says, well, you're absolutely fine to pay it today. Just be aware that, your alert confirmation email is going to say the 15th because I'm not changing that date. So they're not able to change the date, but they can change the number of installments or the down payment amount.
Okay, I believe that gives me all the information I needed. Mr. Banks, I'm going to overrule your objection. While the relevance is somewhat loose and you have established they are in fact the parent company of your vendor, even if they're not your vendor, I'm going to admit Mr. Felber's Exhibit 12 onto the hearing record and give it its appropriate weight, which I'm not sure at this point what that is, but that may be clarified in cross-examination. So Exhibit 12 is admitted onto the hearing record. All right, you may continue your direct examination, Mr. Banks.
Thank you, Your Honor. Ms. Kirschmeyer, when did Ameren, Missouri issue its notice of potential disconnection to complainant, but non-payment as related to the May 19th disconnection?
The disconnection notice was issued on May 4th.
Let's take a look at Exhibit 125C. How can you tell the date that the notice was issued?
The date is located in the upper right-hand corner of the document under the final notice, subject to disconnect after May 16th. You'll see in smaller font, May 4th, 2023.
What does it mean to have cash only under the amount due in the box in the upper right corner?
An account is designated as a cash-only account if there have been 2 return checks or returned payments on the account within a 12-month period. And the account is designated as a cash-only account if there have been 2 return checks or returned payments on the account within a 12-month period. And for Mr. Felber's particular account, the account was designated as cash only in spring of 2021 after there had been 2 return payments on the account. The cash only designation does remain active on an account until there has been 12 months without a return payment. And at the time that this account was closed out, the cash only designation was still in effect.
And although it's called cash only, do you accept certified checks, money orders, or any other form of payment?
Yes, cash only accounts, the payment type that is not accepted would be a personal check. We could still accept a cash payment, cashier's check, money order, credit card payment. The pay now options are always also listed down on the disconnection notice. And so those options are included as well on the disconnection notice.
Under the notice, when would the account be subject to disconnection?
After May 16th, 2023.
Your Honor, I move that Ameren, Missouri's Exhibit 125C be accepted into the record as evidence.
Any objection to admitting Exhibit 125C, the final notice, onto the hearing record?
No objection, Your Honor.
I hear no objections. Exhibit 125C is admitted onto the hearing record.
Did Ameren, Missouri follow the Commission's regulations regarding providing notice of a pending disconnection to the complainant prior to May 19, 2023?
Yes.
Do you recall responding to staff's data request 15 in this case, or Exhibit 113C?
Yes.
How did you obtain the information you included in your response in Exhibit 113C?
That information was obtained through our customer service system, CSS. Additional information was also obtained from another customer service system that our advisors and call center uses, which is called CRM, which stands for Customer Relationship Manager.
So all the information you included in your response, Exhibit 113C, that's information kept regularly in the course of business for Ameren, Missouri?
Yes.
How was the notice of pending disconnection provided to complainant prior to May 19, 2023?
In accordance with the commission rules and our tariffs, we first sent the disconnection notice on May 4th. We also sent a courtesy text notification alert on May 5th, since the complainant was signed up for our courtesy text alerts. We also made 2 outbound collection calls through our vendor message broadcast on May 16th. We made our additional 24-hour AMI disconnection call on May 18th. And so that was all of the appropriate notification made prior to the disconnection.
Your Honor, I move that Ameren, Missouri's Exhibit 113C be accepted into the record as evidence.
Any objection to admitting Exhibit 113 confidential onto the hearing record?
No, Your Honor.
Exhibit 113C is admitted onto the hearing record.
Invite your attention to data request number 10 received from staff, which is our Exhibit 110C. Please explain from the company's perspective why the complainant would receive a call from Ameren's customer service number that would show up on his caller ID as coming from Boone County government.
So we do use a vendor to make our outbound collection calls. That vendor is Message Broadcast, and they only provide the receiving carrier, so the customer's carrier, with the telephone number of our call center, which is 1-800-552-7583. They do not provide any caller ID name with the phone number provided. It's actually the receiving carrier's responsibility to assign a caller ID name with the telephone number that we've provided. So therefore, the receiving carrier, whether that be T-Mobile or AT&T, they're responsible for, from my understanding, querying an online caller ID database and appropriately assigning a caller ID name to the telephone number that we've provided.
So once again, Ameren has nothing to do with that.
That is correct.
Your Honor, I move that Exhibit 110C be accepted into the record as evidence.
Any objection to admitting Exhibit 110C, staff's data request MPSC 0010 onto the hearing record?
I do. She just said it's from her belief. So she's not, I would think you would want a software engineer to go ahead and explain how that works over a customer care representative, but she just explained it's from her belief. So there was
So
nothing.
she said part of it was from her belief. I assume part of it, she received the information from their provider. But
Okay.
is that your only objection?
Yeah, that's my only objection. Otherwise, they can admit it.
Ms. Kirchmeier, how did when you say you contacted your and I don't know what you'd call this, what did you say the company was that provides this?
Message Broadcast is the vendor who handles our outbound collection calls. And I did receive this information. We have our digital team that works closely with Message Broadcast. We received that information directly from Message Broadcast. That is how they explained that they handle this caller ID name concern.
Well, I will agree with Mr. Felber's objection, at least to the extent that this is, I think what he's trying to get to in the long way around is a hearsay objection.
Yes, Your Honor. Yes.
However, the commission is not bound by the technical rules of evidence, and we can admit hearsay onto the record when necessary. Much like several of Mr. Felber's exhibits, I'm going to admit this onto the hearing record over Mr. Felber's objection, but I'm going to say that I'm going to give it its due weight based on the fact that it does appear to be hearsay. So that will be admitted and given its due weight, and that is Exhibit 110C. Exhibit 110C is admitted onto the hearing record. All right, go ahead, Mr. Banks.
Inviting your attention to staff's data request 13 corrected COR, Exhibit 111C, whose name was the customer of record for the account at issue in this case.
The name on the account was Brett M. Felber.
If only complainant's name was listed as the customer of record, was Ameren authorized to discuss the details of this account with anyone else?
No, we were not.
Your Honor, I move that Ameren, Missouri's Exhibit 111C be accepted into the record as evidence.
Okay, Mr. Felber, have you had an opportunity to look at Exhibit 111C?
111C.
Yeah, it is MPSC 0013 COR. It just indicates it
Yeah, I'm the
appears
account holder.
correct. And
Yeah, I have no objection to it.
Okay, Exhibit 111 confidential is admitted onto the hearing record. Go ahead.
Please refer to your response to staff data request 14 or Exhibit 112C. Where did you obtain the information presented in your response to this exhibit?
I obtained this information from our billing system, CSS, customer service system.
So no amounts owed by Mr. Felber on the account at issue in this complaint matter are related to any outstanding balances discharged in Mr. Felber's bankruptcy.
No.
Your Honor, I move that Ameren, Missouri Exhibit 112C be accepted to the record as evidence.
Mr. Felber, any objection to admitting Exhibit 112C, which is data request MPSC 0014, which displays the transfer history for any outstanding balances, and that appears to be that no outstanding balances were transferred to the Florissant address. Do you have any objection to that? Go ahead.
Okay, this isn't 0009, right? This is the one.
0014, MPSC 0014, and it is Ameren's confidential hearing exhibit 112C. So 112C.
I don't have any objections to that. However, 0009 would have a conflicting statement that we would have to go to camera mode for.
Okay, if he brings up 109C, we will go in camera for that, okay?
All right, thank you.
So exhibit 112C is admitted onto the hearing record. Mr. Banks, you may continue your direct examination.
Invite your attention to staff's data request number 22, or exhibit 114C. What procedure does Ameren, Missouri follow when a customer disputes a bill?
When a customer disputes a bill prior to disconnection, we would either suspend the charges to ensure that a disconnection of service didn't occur for that disputed amount, or remove the account from collections and or void any pending disconnection order that has already been issued.
And does that procedure different if the complainant disputed part of the bill?
No.
Was that procedure followed in Mr. Felber's case?
Yes.
Please explain the timeline from 2018 to the present for complaining disputing his bills for electric service at the property.
So as per the data request response to data request 0022, there have been multiple times that Mr. Felber has disputed his bill for his Florissant address. The first time was November of 2018. The amount was suspended during the pendency of a PSC formal complaint that I was working on at that time. The next time on October 8th of 2020, the total balance was suspended to allow time for dispute. There was a PSC informal complaint pending at that time. On April of 2022, Mr. Felber reached out directly to our legal and regulatory personnel and included an intent to sue letter claiming that we hadn't appropriately applied a payment to his account. So we suspended the charges for that dispute at that time in order to investigate and see if we could locate a payment, which we were unsuccessful in doing. So there was also mentioned during conversations, email conversations in April, that Mr. Felber was planning to file a PSC complaint. So again, we suspended the balance to ensure that there was not a disconnection of service during the pendency of Mr. Felber filing informal complaint. In July of 2022, Mr. Felber again reached out directly to our legal and regulatory personnel and advised that he had filed a complaint with the Missouri Attorney General's office. So at that point, we suspended his charges to ensure that we did not inappropriately disconnect service while he was disputing the balance and filing a complaint with the Attorney General's office. I will note that we did not receive an AG complaint at that point. And then in September of 2022, Mr. Felber emailed directly our legal and regulatory personnel, included an intent to sue letter. And at that point, we also suspended the charges to allow time for Mr. Felber to investigate and potentially dispute. So those are some of the instances that Mr. Felber has disputed his bill.
So the customer has to identify the dispute before they get disconnected.
Yes, a dispute must be received prior to disconnection in order to be considered to avoid interruption. Yes.
Your Honor, I move that Ameren, Missouri's Exhibit 114C be accepted into the record as evidence.
Any objections to admitting Ameren Exhibit 114C, MPSC data request 0022 onto the hearing record?
I object
hear no-
because they did not list as early as this year on April 25th, 2023, there was a dispute that was filed and customer service sent it to regulatory, in which regulatory never responded back. But I guess I could do that. If it gets admitted, I could ask it during cross. It's fine.
Is there a reason that wasn't included, Ms. Kirchmeier?
Yes, in April, it was a little bit different. Most of the disputes were received in time for us to suspend the charges. And when the charges are suspended, they're basically put in a hold pattern, and they are not then considered for any collection activity. When he called and spoke with our call center leader in April of this year, there was already a disconnection order issued. So for timeliness, to ensure that service wasn't interrupted, we did not suspend the charges. She just voided the disconnect to make sure that he wasn't disconnect. He was out for disconnect that day. The order had already been issued. So to ensure that we did not disconnect his service, since Mr. Felber had claimed that he was disputing his balance, immediately the disconnection order was canceled. The leader then reached out to our regulatory team, and before we were able to review Mr. Felber's dispute and potentially suspend any charges, Mr. Felber actually set up himself, or someone who logged into his account, I should say, someone logged into Mr. Felber's user ID profile and set up their own payment agreement. So a payment agreement was set up by the complainant or someone who used the complainant's user ID information. And once that payment agreement was set up, there was no need to suspend any charges, because the complainant then is accepting responsibility for that balance due if they're agreeing to set up a deferred payment agreement.
Just as a point of clarification, because this is news to me, I didn't know this. So it appears that there are two ways you can set up a payment agreement, and that would be by calling. You can also set it up by logging into the system under your. Now, if you're logging into the system, I assume that. Well, once again, let's get back to the question. Does a customer service representative look at it, or does it auto-populate from where they've logged into a pending payment agreement?
Well, if you don't mind, Judge, I will explain that there are several different ways that a payment agreement can be set up. It can be set up through a phone call with an advisor. It can be set up if a customer logs into their account online. They can set it up online. They can also set up a deferred payment agreement directly through our IVR, our interactive voice response unit. And I'd have to refer back to the contacts, but from my recollection, this payment agreement in April of this year was actually set up through the voice response unit. So the customer set it up through the IVR.
Is there anyone who reviews it?
There is no review of a payment agreement if it is established by the customer. It's one of the self-serve options that we offer our customers. A lot of customers like to self-serve, so they do have the same parameters around what the payment agreement terms would be, they're going to be consistent in all channels, regardless of how that's set up. So if you set up a payment agreement with the advisor on the telephone, that is going to be those options that are available in that deferred payment agreement window that I talked about a little bit ago. Those values are going to be consistent across all of the channels. So that option is going to be available for the customer to self-serve through the IVR, through the interactive voice response unit. It's also going to be available to the customer if they log into their account online. Those same options are going to be available.
Does it automatically kick out a follow-up email with the pending payment agreement? And the same thing, the mailing out of the pending payment agreement?
But potentially, yes, if they set it through the IVR, I do not believe an alert confirmation email will go out. However, if it is set up through the website, then yes, the customer will have an option to, would you like to receive a courtesy alert confirmation of this? They can check that box to receive an email. Now, that email, that pending payment agreement email confirmation is an option. Now, if a payment agreement if a down payment is received and a payment agreement is actually activated, there's always going to be a hard copy confirmation letter that is mailed. That's one of the requirements. So, and I did, if you don't mind, I did actually flip to the contacts page so I could see what exactly had transpired. And there was a payment agreement, pending payment agreement set up through the automated system on April 25th. So
Is that payment agreement included in the exhibit indicating Mr. Felber's past payment agreements?
It is not, because that in response to that data request, I mentioned that I only included payment agreements that actually activated. This was a pending payment agreement where the terms were set out that a down payment of $2,397 was going to be paid by April 27th. When that down payment was not made, that payment agreement didn't activate. So therefore, it was not an actual payment agreement that was established since the down payment due date was not made. So it defaulted. And then actually the day it defaulted on the 28th, the customer, and we do have to recognize that it's the customer because we do have some disclaimer verbiage in our voice response unit through the IVR that by setting up a pending payment agreement, you acknowledge that you are the customer of record doing this. So I will say that the customer then on April 28th set up a second pending payment agreement with a down payment required of $23.97 that day, the 28th. And that payment agreement, that pending payment agreement also defaulted on April 29th when that down payment was not received. So going back to the initial question, when Mr. Felber called in and spoke to our advisors on the 25th, there was already a payment, an order out for disconnection for non-payment. So there was already what we call a cutout non-pay order pending. When Mr. Felber advised our leader that he was disputing his balance, our leader took immediate action and canceled. She voided that order. She did share that information with our regulatory team. And by the time we got in there to look at this to see if we needed to suspend any charges, the customer had already set up a pending payment agreement, which in our mind, he is acknowledging that he is no longer disputing those charges because he has set up a pending payment agreement. So there was no need to suspend any charges at that time.
And what day was that payment agreement made? You said the 28th of April, is that correct?
Well, the first one was set up the 25th of April. There was a pending payment agreement set up through our voice response unit through the IVR system with a down payment needed of down payment due date needed of April 27th. That was not made. The down payment was not made by the customer. So that pending payment agreement defaulted on April 28th. The customer later went in on April 28th and set up another pending payment agreement with a down payment date needed of April 28th. That pending payment agreement then defaulted on April 29th due to a missed payment. So in our mind, like I mentioned, when a customer voluntarily sets up a pending payment agreement, they are accepting responsibility for those charges. So there was no need for us to suspend any charges due to an alleged dispute at that point.
Now, when you say in our mind, I assume you mean your understanding of how Ameren, Missouri views this. Is that a written policy anywhere, or is that just in some informally, or is that just your personal thoughts in regard to this?
I wouldn't say it's my personal thoughts. I would say that in the rules or in the commission rules or the tariff, we offer a payment agreement to a customer based on their inability to pay their full balance, which they acknowledge in full. So if a customer is setting up a payment agreement because they have an inability to pay that full balance, they are not disputing that they owe that balance. They are acknowledging that they need assistance and need it to be broken up into payments so it's more affordable.
Okay. Based upon the answers you've given me, I'm going to overrule your objection, Mr. Felber, to Exhibit 114C. I'm going to admit it onto the hearing record as evidence of Mr. Felber's past disputes of billing amounts. So Exhibit 114C is admitted onto the record. Mr. Banks, you can continue your direct examination.
Invite your attention to staff data request 23, or exhibit 115C. Did Ameren, Missouri deduct or attempt to deduct funds from complainant's bank account at any time in 2023?
Yes.
What was the justification for doing so?
There was an attempt to deduct funds on May 25th. There were two separate logins to Mr. Felber's user ID, his online account, or his his user ID, which is basically his way to view his information online. But there were two separate attempts on May 25th to make two separate $2,500 payments to Ameren. And both of those payments were unsuccessful, but there was an attempt, therefore, for us to deduct the payments since somebody logged into the user ID of Mr. Felber and attempted to make two $2,500 payments.
And does the term stacking apply here?
I'm not certain with how that would refer to this, maybe.
Your Honor, I move that Exhibit 115C be accepted into the record as evidence.
Any objection to admitting Exhibit 115C? Which
I would
appears,
assume it's these snapshots of my account, correct?
if it says 115C at the bottom, I believe so. It is MPSC data request 0023.
Yeah.
I think what Ameren is offering to show is that it appears that somebody through your account portal attempted to make payments on two occasions. And I think Ameren is offering it for the purpose of showing that they did not initiate that, but who knows?
They did not. I guess with that, if that pertains to auto pay, they never sent me out a letter confirmation like they're supposed to that states that you've put yourself on auto pay. They did send me a cancellation of auto pay, but they never sent me out a letter confirming auto pay like they're supposed to.
Okay, you can ask questions about that. I'm going to, is that an objection?
No, I don't have an objection to it. No.
Okay. Exhibit 115C is admitted onto the hearing record. Go ahead, Mr. Banks.
Invite your attention to staff data request number 24, or exhibit 116C. did Ameren, Missouri prevent complainant from canceling his account?
No.
Please walk us through what happened.
So on a high level, when there are multiple service orders pending for a premise for the same address, we refer to those internally as stacked orders. So the system doesn't know which order to take or which order has priority if there are multiple similar orders pending for the same date. So with Mr. Felber's account, and I'll back up just a titch. So once there's some differences, some terminology that I might want to clarify. When an account is disconnected for non-payment, that account stays active. That account stays active in order to allow the customer time to make a payment, have the services reconnected without there being any change to the account number of the account. So in order to disconnect the service, which with our terminology really just means that you're final billing out the account, you're closing out the account. But in order to disconnect the services was first received online by someone who had logged into the online account on June 4th. And that one was immediately canceled by the order. There were several other account service orders that came in on that address for different connects of service, different disconnects of service. And there were a total of 14 service orders that came in for this address at the same time within days of each other that stacked up on top of each other. And that's what we kind of refer to as the stacked orders. So our system was bogged down and did not know which order to process. So we actually have a specialized group that if there are multiple service orders pending for the same account that are stacked, they go to a specialized group so they can start weeding through manually these orders because the system isn't able to process them through. So it took several days, took quite some time for the system and the group that was manually looking at these orders to realize which orders needed to be canceled out, which were some of these connect orders that were pending for various names, like the LLC, and which account which service order should actually be the one that needs to complete. So, the May 19th disconnect order, which effectively closed out the account and generated a final bill, was finally able to be processed through the system on June 21st. So we did not prevent the account from closing out. However, due to the multiple service orders that had been entered and the system having to weed through those and a manual intervention needed, it did take some time before that final bill was generated.
Once again, was a final bill issued?
Yes,
And when was it issued?
on June 21st, with an effective date of May 19th. So the account was, in fact, closed out the date that was requested.
Please refer to Ameren, Missouri Exhibit 105C. Is that the final bill issued on complainant's account?
Yes.
Your Honor, I move that Ameren, Missouri Exhibits 116C and Exhibit 105C be accepted into the record as evidence.
Let's take those one at a time. Any objection to admitting Exhibit 116C, which is MPS C data request 0024?
No, Your Honor.
Okay, Exhibit 116C is admitted onto the hearing record. And Exhibit 105, that is the final bill, correct?
Yes, Your Honor.
Any objection to admitting 105C onto the hearing record?
No, Your Honor.
Okay. Exhibit 116 and Exhibit 105 are admitted onto the hearing record. Go ahead, Mr. Banks.
Invite your attention to staff status request 25 or exhibit 117C. The Ameren, Missouri employees entered the property without the permission of the resident or homeowner on June 15, 2023.
No.
Please explain what happened.
So there was a service order issued for June 15th for a service disconnection at the transformer. And one of our field workers, who was accompanied by his supervisor for assistance and support, did go to the location on June 15th, but there was no need to enter the property because they were disconnecting the service at the transformer, and the pad mount transformer was actually 2 homes down from Mr. Felber's. So there was a house in between them. There was no need for any access of the property in order to complete the service order, which was to disconnect service at the transformer.
Why was service disconnected at the transformer?
So once we were aware that there had been unauthorized requests to start service that had been completed through our website, there was a need to ensure that there was no remote connection of the AMI meter. And in order to prevent any remote connection or disconnection of an AMI meter, service must be disconnected a little bit further back at the transformer. And so that's why the service was disconnected at the transformer.
Yeah, I move that exhibit 117C be accepted into the record as evidence.
Can I ask a clarifying question?
Yes.
If it's an AMI meter, why is there, if Ameren is controlling the meter, why is there a danger of anybody connecting it?
Well, it had come to my attention that the service, the AMI service, had been turned back on because there had been an online request for a connection in a Dividend Park Investors LLC. This request was done online, and an order for connection was accepted online without any intervention from any employees, and the AMI service was actually turned back on at this address. Once that came to my attention, as per our tariff, there is, we are able to disconnect service without prior notification for the reason of obstruction. And obstruction is further defined in our tariff as including unauthorized use of service. And this was a clear case of unauthorized use of service or obstruction because the service at this address should not have been turned on in an LLC name. It was not, would not have been appropriate because of so many, we would have at the minimum have to have done an investigation to determine that there was no benefit of service that had occurred, that the LLC was in fact the owner of the property, which I know from my research that this LLC was not the owner of the property. So we were able, so we had the AMI meter remotely turned back off immediately. And at that point, in order to prevent any future online unauthorized connect requests from being accepted on the website without any investigation, it was determined that the service would be disconnected at the transformer.
Okay. When you say an AMI meter is activated, is that the same as turning the service on? I mean, was electrical service turned on at that point?
Yes.
Okay.
Yes.
All right, any objections to admitting exhibit 117C? Ameren's response to staff's MPSC data request 0025 onto the hearing record?
I do. The date is inaccurate, and services were already off, and it was actually the date that she's saying it wasn't in the Dividend Park. It wasn't in any of my property investments. It was actually my wife, Lisa Lambert, and services were already off. They said they turned it on, but that would have already happened at the pad mount where they disconnected. So there was no, while they can say they turned on the meter, no meter was ever turned on.
Okay. When you say it's the wrong date, what do you mean? Which date is wrong?
Uh, services never came on.
I understand that. And did
It would have been the date of, it would have been the date of, that they actually came out. The 15th to do the disconnection at the pad mount, because there's a couple discrepancies even in here where they spelt my wife's name wrong. They spelled it as Lysa, and they said it didn't register back to the same social security number. And then that's where she's saying that services were turned on. Services were never turned on simply because of the fact of at the pad mount, it was already disconnected. And my wife actually called them to ask them when they were going to come out to do a connection. And they said, your remote service will be connected shortly. Or if there was anything else. And that's when I went into further pending investigation, and it was kicked out because we also had to file a complaint with my wife because they failed to send out a denial letter until after an informal complaint. I mean, it can be omitted if you want it to. I'll just use it as a cross.
Well, thank you, but I do need to address your objection. I'm going to overrule your objection. I'm going to admit it for the purpose of showing that on the 15th, service was disconnected at the pad.
All right. Thank you, Your Honor.
I'm also going to allow her surrounding testimony in relation to that. But you're certainly welcome to question about it on cross.
All right. Thank you, Your Honor.
You may continue, Mr. Banks.
Invite your attention to staff's data request 26, or exhibit 118C. The complainant applied for a medical hardship before his electrical service was disconnected.
No.
What is the process for applying for a medical hardship extension?
So a
Can I
medical
just-
hardship extension must be
Hold on just a second.
received.
Hold on.
I'm
I
getting,
believe staff
getting-
is,
yeah, I'm getting quite a bit of feedback from Mr. Banks when he's speaking. I don't know if there's something he can do or whether it's on my end or his end, but I just want to mention if there's something you could do, Mr. Banks, I would appreciate it. Thanks.
you know, Mr. Banks, you're in the room with Miss Grubbs, correct?
Yes, Your Honor.
Is there any danger that that whatever she's using is picking up, or is she currently muted?
I think she's muted, Your Honor. I can move closer to the mic. I apologize for this.
Okay, thank you.
Okay, I'm receiving a thing from our hearing technical personnel that's indicated that your speaker might be up a touch too high. So
Okay, thank you.
that might correct it. But I also want you to be able to hear us clearly, so don't turn it down so that you can't.
All right, thank you, Your Honor.
I don't hear any feedback. Mr. Keeble, are you still getting any feedback?
It's better since he moved forward.
Okay.
It got better when he moved closer. Thank you.
Okay, if you're having difficulty hearing in the future, will you let me know? All right,
Yes,
go ahead, Mr. Banks. I apologize. I believe we were talking about Exhibit 118C.
Yes, and I will repeat the question. Invite your attention to staff's data request number 26, exhibit 118C. The complainant applied for a medical hardship before his electrical service was disconnected.
No.
What is the process for applying for a medical hardship extension?
So a request for a medical hardship extension must be received directly from the customer's doctor, physician on their letterhead, and it must be faxed directly to Ameren, Missouri, and it must be received within 24 hours of disconnection in order to be considered.
Please explain the timeline of what happened with Mr. Felber's account.
in regards to the medical hardship extension.
Yes, please.
So we did not receive any medical hardship extension request until I believe Mr. Felber filed it in EFIS in June. He filed a letter from a doctor in the complaint matter. But again, since it had been received well after 24 hours after the service was disconnected on May 19th, we were not able to consider that.
Your Honor, I move that Exhibit 118C be accepted into the record as evidence.
Any objections to admitting Exhibit 118C, staff's data request MPS C0026 onto the hearing record?
No, Your Honor.
Exhibit 118C is admitted onto the hearing record. Go ahead.
Are you familiar with the staff's report, which has been designated as Exhibit 200 as relates to this complaint?
Yes.
Do you agree with staff that there is no credible reason to believe that Ameren, Missouri violated a statute, regulation, or tariff as relates to this complaint?
Yes, I do.
Does the company agree to exploring retention of pending payment agreement confirmation emails for more than 30 days as mentioned by staff in Exhibit 200?
Yes, we do. And we actually will have that in place by the end of the year.
Can you describe when pending payment agreement confirmation emails are sent?
A pending payment agreement courtesy email is sent as soon as the advisor has, or as soon as the pending payment agreement has been set up. So whether or not it's the customer who has requested an email confirmation or an advisor, it is sent directly at the same time.
Please refer to Ameren, Missouri Hearing Exhibit 122C, which is a pleading titled Union Electric Company doing business as Ameren, Missouri's request for leave to file response to staff report and response to staff report.
Okay.
In Exhibit 122C, the company agrees to retaining pending payment agreement confirmation emails as it shifts to a new vendor.
Yes.
To clarify, are you aware of any commission rule or order that requires the company to retain the pending payment agreement confirmation emails?
I'm not.
Does the company agree to examine its payment agreement language as described by staff's report?
Yes, we do.
Has the company examined its pending payment agreement confirmation email verbiage?
Yes.
What did the company conclude?
So we appreciated staff's recommendation. It did give us an opportunity to look at this in more detail and agree that there was a potential for customer confusion with our pending payment agreement alert courtesy emails. Specifically, there was a statement that said a payment agreement has been established when in actuality it was a pending payment agreement. So we have revised our alert confirmation email language to specifically say your payment agreement is pending an initial payment. And it's we've made some changes to better enhance the customer experience, and we hope to have those in place, if not by the end of this month, and then by the beginning of November.
And Your Honor, once again, we move that Exhibit 122C be accepted to the record as evidence.
Any objection to admitting Exhibit 122C, Union Electric Company doing business as Ameren, Missouri's request for leave to file response to staff report and response to staff report onto the hearing record? I hear no objection.
Go ahead in a minute. I'll ask and cross. Go ahead, Your Honor.
Okay.
I have no objection.
Okay, Exhibit 122C, the request to for leave to file a response to staff's report, and said response are admitted onto the hearing record. Please continue.
Has the company prevented complainant from reestablishing electrical service to the location?
No.
What is your recommendation to the commission regarding this complaint?
My recommendation is that the complaint be denied with no violations found.
Your Honor, I have no further questions at this time, and I tender the witness for cross-examination.
Okay, it is now 10:20 a.m. We've been going for about not quite an hour and a half. Is there anybody at this time who would like to take a short break before Mr. Felber's cross-examination?
It's up to you, Your Honor. I'm whatever.
It is up to me, but I'm querying. Go ahead.
I may be wrong, probably am about this, but I thought staff was going next on Ms. Kretschmer, and then Mr. Felber was going last, since he was the most adverse to this witness's party.
We can do that. I'm happy to do that. That's not what my note says. Mr. Felber, did you want to go next, or did you want staff to go? I guess the relative advantage to having staff go is they may ask questions you have not thought of, or they may ask questions that may lead you to want to ask additional questions. So I will leave that to you, but I have written down, when I queried everybody at the beginning, I had suggested this order and nobody had objected to it, but I am happy to flip Felber and staff.
I
Yeah,
won't
that's
have very many questions, I can tell you that.
Go ahead, Mr. Keeble. I did not catch that. I apologize.
I just said I won't have very many questions.
Mr. Felber, would you like to let staff question first?
Yeah, absolutely. Go
Do you
ahead.
have objections to staff questioning first?
No, I do not have any objections to staff.
Okay, I will make a note that I am flipping those. Now back to my original question. Is there anybody at this time who would like to take a short break? I'm hearing none at this point. Oh, I'm sorry. Go ahead. Thank you, Ms. Hefner.
Your Honor, I would request just 5 minutes, please.
Okay, I usually don't take 5-minute breaks. I usually like to take about 10 minutes to be sure that everybody has enough time.
Thank you.
It is now 10:22. Why don't we take an even 15 minutes to make it, all right, and let's see, come back at 10, what is that, 37? Is that correct? Is that 15 minutes? Okay, so we'll all be back here at 10:37. We will break for a short recess and we will go off the record.
Thank you.
As it is now 10:37. Do I have attorneys from Ameren?
Your Honor.
Thank you. All right, let's go back on the record. And I see we have started the recording again. Ms. Kretschmer, I'll remind you that you're still under oath, and staff, it is your turn to start cross-examination. So Mr. Keeble, go ahead.
Thank you, Judge. Like I said, I don't have many questions. Ms. Kretschmer, let me ask you, in response, in conversation with the judge earlier during Mr. Banks' direct testimony or examination, you were talking about the process of when a customer is on the phone with a CSS representative and what the CSS representative can change and what they can't change. You recall that, ma'am?
Yes, I do.
During that conversation, I believe you stated that the CSS representative can change the number of installment payments under the payment agreement and the amount of the monthly installment and possibly the down payment required. But you stated, I believe, that the CSS representative was not able to change the date of that was what you said, was the CSS representative is not able to change the date. Do you recall that?
Yes, I do, and that is correct. The date
Well,
field is not able to be changed. I'm sorry.
What date are you referring to there, ma'am?
That is the down payment due date to activate the payment agreement.
Okay, the down payment due date. But your position, as I understand it in this case, is that the pending payment agreement that Mr. Felber has submitted a copy of, or a copy of, had the date altered. Is that correct?
That is correct.
So when you say the CSS rep cannot change the date, but that date is altered, I'm a little confused there how that could be altered, but the CSS rep cannot. Can you explain that to me?
Well, that is what leads me to my assertion that that document was altered, because that date would have been May 18th on that payment agreement that was established as a pending payment agreement on May 18th. There would not have been the ability for the advisor to push that date forward to May 22nd. It would not have been, that's not a field that's editable.
Based on the template that the CSS rep works with when initiating the agreement, is that correct?
That is correct. Within the deferred payment agreement window, yes, that down payment due date cannot be changed.
But you believe that it was changed in the version that Mr. Felber has provided to the commission?
I do believe that that document was altered, yes.
And that was based on a discussion you had with the, I believe you said the, I forget what department it was, but it's another department there at Ameren, correct? Some engineers,
Yes, our software engineers indicated that they believed that that document had been altered, and from my personal experience, I believe that as well.
Okay, so that would have been through a different access method than what your CSS representatives use when setting up the agreement.
Yes, and to clarify, even if the agreement had been set up through another means, whether it had been through the customer online or through our voice response unit, any means that that payment agreement had been established, that due date would have said May 18th, any Ameren means of establishing that agreement.
Right, okay. But you still believe it was through other means able to be changed by someone, but not someone not at Ameren.
I do believe, yes, that there is there was the functionality available to edit a document to make it look authentic.
There you go. That's what I was trying. I was trying to understand how those two fit together. Now I think I do. You also mentioned, I believe, that Mr. Felber has had, prior to this May 18th payment agreement or pending payment agreement, or whatever it was on May 18th, prior to that agreement, he's had several previous payment agreements, correct?
There were several payment agreements that were actually established, yes, and there were many multiple payment agreements that had been set up as pending but never activated because a down payment wasn't received.
Okay. Do you recall, and if you don't, that's fine, but do you recall how many actual payment agreements he's had previously?
From my recollection and my data request response, I'm thinking maybe 5 or 6. Without looking back into my actual document, that figure may be wrong, but I think approximately 5 or 6 were actually established.
Okay. Now, you, during your testimony, I guess it was Friday, I believe Mr. Banks played recording of a phone call between Mr. Felber and one of Ameren's customer service representatives, in which the representative says the payment agreement, or excuse me, the down payment will be due today, back close of business today, and Mr. Felber, Friday, I believe it was, indicated that nowhere on that phone call did either he or the Ameren representative indicate what day they were having that phone call. Do you recall that, ma'am?
If you're referring to the call between Mr. Felber and our advisor on May 18th, then yes, I would agree that on that phone call, the specific date, today is May 18th, was not discussed.
Okay. Now, you listened to the calls previously prior to responding to staff's data requests and determined that that call was in fact on May 18th, correct?
Yes.
And could you very briefly again explain to me how you determined that?
Yes, I sure can. So in the recording system that Ameren, Missouri uses, which is called ICBM, there is every phone call that is recorded and stored within that Ameren system has an interaction ID associated with it. And the interaction ID is a long string of numbers. The first set of numbers are what are unique to each call, but the last 6 digits of every call that is recorded within that system of the interaction ID is the date. So it's 05, for example, for this particular call, when I pulled it, it ended in 051823. And instead of saving all of those calls with that very long interaction ID number, in order to make it easier for staff to identify which call goes with which account contact, I renamed all of those WAV files to the date of the call. So I eliminated the first string of identifying numbers and saved it with 0518. But in instances where there were multiple phone calls recorded for a specific date, for example, there were probably a dozen calls on 0519, I edited the name of the WAV file to say 0519 first call, second call, and so forth, because otherwise it would be really nearly impossible for a staff member when they're listening to these calls to be able to match them up to what call they fell into in the account contacts.
Okay. I think everyone is in agreement that the service was disconnected on May 19th. Is that your understanding, ma'am?
Yes.
Okay, so my question is, there are different types of payment agreements. I believe we've already mentioned, someone mentioned cold weather payment agreements. And would you agree that there are multiple types of payment agreements that customers can receive based on the circumstances?
Yes, sir.
What do you call this? Is there a specific name given to this type of payment agreement that we're dealing with here?
Internally, we would refer to this as a non-cold weather rule payment agreement.
Non-cold weather rule payment agreement. Okay. Okay. Now, if the is it possible for a customer to receive one of these payment agreements after service is disconnected?
Yes.
How long after can you receive one of these payment agreements?
I previously mentioned that our advisors have access to a deferred payment agreement, a DPA window, which automatically gives them all of the options available to a customer. And The circumstances for a payment agreement would not change in non-cold weather rule until the account were closed out or finalized, because at that point, they may be required to make a different type of a down payment since the account is no longer active. So with Mr. Felber's account, the payment agreement would have been an option for him up until the point that the account actually closed out. And I also mentioned in my testimony earlier that it did take some extended time for us to actually close out his account. It wasn't finalized out. I finalized out until June 21st. But typically, a customer has the same options available in non-cold weather rule up until the time that the account is actually finalized out and a final bill is generated.
Okay. What's the point then of the agreement that, or I guess that's not an agreement, that's to have one service turned back on after disconnection. There's a requirement of 40, is it 40% or well, what's the other agreement option that has been quoted to Mr. Felber? Hasn't an option been offered to him?
So prior to the account closing out, there was an option to pay 50% of his balance and then the remaining amount deferred over 12 equal installments. Now that the services have been, the account is completely closed out, there's a requirement that 80% of his full account balance be paid up front, and then we would take the remaining 20% and defer that over monthly installments. So there is still an option right now for a payment agreement.
Right, the 80%. Thank you for. I had half of 80. I was thinking half of 80%, but the 80%. So why would you have, or a customer have, both options available? You said until the account was closed out, that non-cold weather rule payment agreement would be available, which would only require 50%, whereas under the other option to have the service reconnected, I guess that's after it's disconnected that one comes into play.
Correct. And that would also apply to customers who are wanting to start service somewhere and they have an outstanding written off from maybe years, several years before. They would also have an option then to pay 80% of their account balance up front before we would reconnect service at the new address.
Okay. Okay. Well, thank you, Ms. Kretschmer. I think that's all the questions I have for you. Thank you.
Thank you.
Thank you, Mr. Keeble. Mr. Felber, do you mind if I ask a clarifying question based upon what Mr. Keeble asked?
Yes, Your Honor.
Yes, you mind, or yes, you don't mind?
I don't mind.
Okay. I'm confused, Ms. Kirchner, and it's just maybe there's a word I missed or something, but you had indicated that they can receive a pending payment agreement after disconnection has occurred, correct?
Technically, yes, we would offer that, but once again, that payment agreement would not be established until the down payment were made.
Okay, I see where my confusion is now. So when you say, you're talking about in terms of making an agreement, correct? You're not talking in terms of the notice being sent out.
Yes, yes, Your
Is
Honor.
it possible? I mean, theoretically, in my mind, it's impossible for them to receive at least an email notice of a pending agreement after the disconnection occurred. Would that be correct?
So once services are disconnected and is the account
I'm not
still
talking
active?
about, I'm not talking about a post-disconnection application for a
Okay.
payment agreement, because that's everything's occurring after disconnection.
Okay.
I'm talking about if the service hasn't been disconnected, somebody through one of the three ways you indicated makes a payment agreement. Well, it would be one of the two ways, because I guess one of those does the voice the computer voice one does not allow for an email. But the other two ways do allow an option for an email. If you're making that kind of payment agreement, that's clearly not post disconnection. So again, it's not, would you agree that it's not possible for somebody to receive an email version of their pending agreement after disconnection if they've made their, if they've set up their agreement prior to disconnection?
If the,
Or is there a tiny window there where disconnection could occur and the agreement's received in the email?
so hypothetically speaking, if a pending payment agreement were set up and it was on the day of disconnection, well, actually, then it wouldn't be an option. So if it's on the day of disconnection, then it would have to be set up prior to disconnection in order for an email confirmation alert to be sent.
Is it not possible to set up a payment agreement on the day of disconnection?
It is possible, and that's kind of where that window you talked about, but it's very clearly explained to the customer that you are there's already a disconnection order that has been scheduled for today. So it's possible that your terms may change depending on if you get your payment in before the disconnection occurs or not. The system does, especially with AMI meters, it's really, since AMI meters are able to, they always do a last ping of the system to look for a payment. So if a payment's been received, they would not perform the remote disconnect on the day of disconnect. So that's kind of nice with the AMI meters because there's always a last quick check. Okay, has this customer made the required payment to avoid disconnect? And if so, then the AMI meter remote disconnect wouldn't occur. So I'm not sure if I answered your question or not.
You did. You answered it. Thank you. Okay, Mr. Felber, you may go ahead with your cross-examination.
All right. All right. So at the beginning of everything you said, you do the customer care training to make experiences better. Correct, Ms. Kirschmer?
I'm not in our training department, Mr. Felber. However, I do work closely with our customer experience department to share information to help make our customers' experience better.
Okay. So your company is it's not new to scams. You guys post on your guys' website, hey, to watch out for these kind of scams or people spoofing information. In fact, there's one on your website that says right now there's a senior scam going out. $29.99. Scammers pose as Ameren employees offering special rate in lieu of paying a customer or full monthly statement. So the reason I bring this into things as well is because knowing that there were several phone calls and you even listed in your exhibits, there were phone calls that were regarding that. What protective measures did Ameren do on that matter to say, hey, how do we solve this? How do we, what kind of blast did you guys put out or even send to me instead of saying, oh, well, it's your provider? What kind of things did you do to assure it was a protection, a comforting? When somebody sees something that shows up in a Boone County government, or there's even, I can go through a list on Google of Fox 2 showing that people advertising themselves as sheriff's officers saying, hey, unless you get a green dot card and pay your bill. What did you guys physically do to see and stop that from occurring any furtherance, or what protection measures did you guys put in place to that?
Objection, relevancy, plus it's a compound question.
I think it explains a lot because.
Hold on, Mr. Felber. If there was a compound question, I missed it. I saw a lot of narrative set up, but the question at the end of the day, I believe, was what does Ameren do to prevent these kind of scams where people may use their phone number? Is that correct, Mr. Felber?
Yes, Your Honor.
Okay. That, I'm going to overrule the objection then. Ms. Kirchner, would you answer Mr. Felber's question?
Although I can't specifically,
To the best of your knowledge.
to the best of my knowledge, I do know that we do have a lot of customer education available. Mr. Felber mentioned on our website. As far as particular, I'm not aware of any particular scams where there has been our phone number assigned to a different caller ID name. So I really can't answer that specifically. I'm sorry, I don't really have information about that since I'm not familiar that this has happened with any other customers.
Okay, so your answer is I don't know.
Yes, in a long way, yes.
Okay, go ahead, Mr. Felber.
Another thing that I'll mention it, which kind of disturbs me. At the beginning of this, your statement.
We're not going to mention things. This. If you mention something, it's got to flow into a question.
Okay.
It's not testimony. You're not testifying at this point. You're asking questions.
Questions, yes. You mentioned that you spent time trying to alter documents at the beginning. Why would you mention that? You just opened up that at the beginning of this, that you went into your, even though they were your own personal emails. Why would you do that? Why would you mention that?
Yes, I would love to answer that for you. When I was investigating this complaint and the senior software engineer mentioned that there was the possibility of anyone downloading an email and editing it, I wanted to take it one step further and see for myself personally if that was an option. So for purposes of investigation and for me being able to testify that I personally could agree with what the software engineer shared with me, I took my own personal Outlook account and I downloaded emails to see if they could be edited. And I forwarded emails to see if they could be edited. And like I mentioned, I was surprised at how easy it is, but I'm glad that I was able to do that with my own personal. I'm an Ameren, Missouri customer myself, so I receive Ameren emails from my home account. So I'm glad that I was able to do that myself, so I could agree then that it is very easy to do, and it's very easy to edit emails, and they seem very authentic.
Okay. So you did spend time altering emails though?
I didn't save any emails, but I did, for purposes of investigation, my own personal emails. Yes, I did edit those to see if it was in fact easy, and it is.
Okay, so I guess leads me to my next question. When you guys received a copy of it, you guys use SendGrid, correct? SendGrid's parent company is Twilio.
We received a copy of what?
When they received a copy of the payment agreement,
Okay.
instead of going in your email and seeing to edit things, wouldn't it be easier just to call SendGrid and say, hey, this customer has this, is what he's showing me. He got a copy of it. Wouldn't it be easier just to call SendGrid and say, hey, can you look up that data retrieval? Or Twilio, their parent company, which even shows on there how you follow the process. Wouldn't it be easier just to call them and ask them for some sort of verification?
If you're referring to the document that you shared with us, which was a copy of what appears to be an altered email confirmation with a different May 22nd due date, we did reach out to SendGrid to see if they could authenticate that document. And the information we received from them was we sent out the email on May 18th with the values that were inserted from your billing system, which had the required due date of May 18th.
So they didn't send the exhibit that you submitted was a spreadsheet of how it works, how you input the values and everything. That's not from SendGrid. That's your system of how you use it. That's not a piece of paper from them. I would think you would have a copy that shows something and says, hey, you know, this is coming from my, I guess, perspective. When you put it in here as an exhibit, you're putting in something that you're inputting values. Nothing on that piece of email that you entered in as an exhibit shows anything with SendGrid's name or doesn't even say anything with the payment agreement.
Mr. Felber, is your question, and I'm just trying to clarify here because you do include a fair amount of narrative in your question. Is your question essentially if they queried SendGrid about this, why isn't SendGrid's response an exhibit?
Yeah. Yes, Your Honor.
SendGrid advised us that they no longer had a copy of the email that they sent out since we were requesting this more than 30 days after that email was sent out. SendGrid advised that they only kept copies of their emails for 30 days. So it wasn't a timely request. If this had been asked of them even a couple of days earlier, they would have had a copy of that email. But since it was after 30 days, the only information that SendGrid was able to provide was confirmation that they used the values that we provided them to include in that email.
Next question. Pertaining to the payment, I noticed when you were talking a couple times, you went back and forth between the interchangeable of payment agreement and pending payment agreement. Now, who actually physically does the template for your payment agreements?
I'm not sure what your question is, but there is not a template for a payment agreement.
Okay. So when it comes out in the email, it shows everything there from all the way from Ameren, Missouri's email, and then it says your payment agreement has been established. Who inputs that? I mean, there's got to be somebody that's essentially you guys, your software team or whoever discusses this has to put input stuff, correct? I mean, it doesn't just show up as payment A, B, C, D. It gives you a list of detail. What I'm saying is the payment agreement, who puts the values in?
So if are you referring to the emails, the courtesy alert confirmation email?
Shows
Is
the
that what
payment
you're referring
agreement.
to?
Sorry for interrupting you. Yeah. So it shows payment agreement. It shows payment agreement terms, what it is, the account number there, so forth. Who inputs that? So the wording that is on the document that says your payment agreement has been established.
All right, I'm gonna, Mr. Felber, can I break this up? Because I think
Yeah.
you're asking two questions here.
Okay.
It seems like one of your questions is there's fields that are populated with things such as dates and numbers. And then outside of those fields, it appears that there's some standard language for these pending payment agreements. It seems like you got two questions going, which is who is it that comes up with this standard language for these agreements? And then the secondary question of who inputs the inputs that populate the fields, the blank fields in the language that's the agreement. Is that correct?
Yes, Your Honor.
Okay. So again, let's start with the first question, which is who designed the language that I guess Mr. Banks had indicated that Ameren is agreeing with staff and wants to make some changes to who designed the language? Do you know who designed the language that was used for this payment agreement email?
I can answer that, Judge. There is, it's generally a collaboration. There would be folks from the business side, so from the actual customer service, credit and collections side as a part of the team. There's also digital employees as a part of the team, as well as our corporate communications team. They would work collaboratively and to develop the language and the layout of that actual pending payment agreement alert confirmation email.
Okay. And who populates, and I think you've covered this already, but I kind of want to hear it again. Who populates those fields? How are those fields populated?
That information is pulled directly from CSS, our customer service system. So the information, like I mentioned, is pre-populated for the most part. Well, the date is not able to be changed, but the down payment and the installment numbers and the amount of each installment is pre-populated. And the information from that, which is within our CSS system, is automatically sent over. So it's not, it happens behind the scenes, and I am definitely not an IT guru, so I apologize, but I know it's pulled directly from CSS into the information, then that message broadcast, or I'm sorry, SendGrid actually used to send out. We are transferring to message broadcast for future emails for the retention purposes we talked about earlier. But yeah, SendGrid is the one for Mr. Felber's particular case that has sent that email out.
And Mr. Felber, I'm not sure if I accurately captured your questions. If I did, great. If not, please feel free to ask again.
You did a great job for me. Again, I'm kind of new to this, so questions, how they come out, I apologize. So would you agree that how it says payment agreement on there instead of pending payment agreement, wouldn't you want to have a boundary that sets different, like a disclaimer that's into that says, hey, like it was discussed, and I know you guys are switching systems, but can you see where it's misleading to the customer, where it says your payment agreement has been established? Nothing in there indicates that it's a pending payment agreement. So it's kind of a misrepresentation of what you have, correct?
I agree. And as I mentioned already, we agreed with staff's recommendation that we revisit the verbiage of that alert confirmation, pending alert confirmation email. I do agree that there was an opportunity to clarify that this payment agreement was not activated until you make your down payment. Although I will agree that it was clear that there is a due date, and it mentions once the payment agreement is activated, then you will receive a confirmation letter. So although there was rooms to enhance the verbiage to make it a better experience for the customer and less confusion, I also do think that the way it was at the time that you received it also made it clear that there was a down payment needed by May 18th in order to activate the agreement.
But that kind of revolves around the payment agreement that shows different, but I won't bring that up. What's the difference between a pending payment agreement and a payment agreement?
Pending payment agreement is what is agreed to in order to activate a payment agreement. So a pending payment agreement is an agreement that the customer says, I will make this down payment, and once I do so, I will be entered into a payment agreement with the terms that were laid out.
Okay. And I guess that question that goes with that terminology in terms of disconnection of services, if it's the commission brought it up or the staff brought it up in their staff report, if it's actually a payment agreement, there's different circumstances in what would have to be followed than on a pending payment agreement, correct?
Well, I would actually disagree with that, because in any situation, a missed payment leads to a default of a payment agreement and an entire balance becoming due. So even with a pending payment agreement, if you've missed that down payment, your entire balance is then due, similar to if the payment agreement had actually been activated.
So in staff's report, it shows if you have a payment agreement, the circumstances of how it's worded would be you know, the extent, how much, where you reapply everything, which something that baffles me too, in the staff report, you guys mentioned that you guys failed to send out you guys agreed with the commission. It was on page 10, I believe, of the staff report, that you guys failed to send out a default letter, personal service, or first class mail. Why would that be if you followed commission rules, tariffs, regulations?
Mr. Felber, I will either ask you to point me in the staff report what you're looking at, or maybe clarify a little bit more, because I'm not really familiar with what you're referring to right now.
So on the staff's report, page 10 of 13, Ameren sent an agreement in writing, which technically it was emailed, but still, Mr. Felber. However, Ameren did not notify Mr. Felber by personal service or first class mail about his default prior to his disconnection. And Ameren's response to staff DR 0027, it states that it has an email template it uses for these confirmation emails. Staff has submitted a data request to the company as of July 21st, 2023, requesting a copy of the template. Without this information, staff cannot determine what is sent to the customer in these situations. So on page 10 of the staff report, in the official case file memorandum, right here, you guys admit that you failed to send out the default letter for the payment agreement. If the payment agreement was on the 18th, like you say, you still didn't follow commission rules, tariffs, regulations, because you failed to send out a default letter. Correct?
Well, I would actually disagree, because that payment agreement had not been activated. So although you technically defaulted on a pending payment agreement, there was actually not a payment agreement established where we would have been required to send notice.
It says right here, it doesn't say anything about pending or payment agreement. It just says Ameren did not notify Mr. Felber by personal service or first class mail about his default prior to his disconnection.
Objection asked and answered.
That'll be sustained. That has been asked and answered, Mr. Felber.
All right. The next question is, wouldn't you want, I mean, I understand you're a witness to this. There's some things that you cannot answer for, you know, Ameren, like IT questions. Wouldn't it have been appropriate to have a staff member as a witness, just so that way they could go ahead and explain how their system works? I mean, I would have. But
Can you clarify that question, Mr. Felber? I'm not sure I understand the question.
some of the questions she couldn't answer, which pertain to IT.
Mm-hmm.
Wouldn't it have been smart to have an IT person that could explain those behind the scenes of how their IT portion works?
So I guess your question is,
That's my question.
yeah, would having an IT person present facilitate answering some of the questions that you could not?
Correct.
Objection, argumentative. Relevancy.
I think relevance, I think it's relevant.
I'll take it as there's no answer.
No, just wait, I'm thinking about this because the speculative bears out two different ways of looking at it. I'm going to sustain that. I think it's self-evident that if she couldn't answer the question, that an IT person probably could have answered the question better. So I'm going to sustain the objection.
And back to the payment agreement. We'll talk about that. I appreciate your answer on that. However, the verbiage, what it comes down to, payment agreement or pending payment agreement, it's misleading. That would be like somebody inserting an additional word saying, oh, well, it's really pending when it's not pending, even though there says payment agreement. Wouldn't you agree with that? You're inserting a new word that was not put on the paperwork?
What's the new?
Objection,
Hold on.
asked and answered.
I'm going to hold on that just for a section. What word are you talking about?
Well, the email shows payment agreement. So by her going and saying, well, it's really a pending payment agreement, she's wanting to alter the payment agreement to where it says instead of payment agreement, pending payment agreement, when it's really verbiaged as payment agreement, correct? I mean, when I take a spelling test and I would have to say the word here, which definition of here? Oh, well, that would be like getting the definition wrong and then saying, oh, well, I really meant that definition. So now we need to move on to this and go ahead and mark it different.
Well, I think at this point we're quibbling about what language within the agreement means, and that's a fine subject for cross-examination. So I certainly don't have a problem with you doing it. But the thing is, at least the email that I'm looking at is supportive of both positions. It says your payment agreement has been established, as you pointed out. It also, in the immediate line below that, says the payment agreement has been established for your Ameren, Missouri account. But then it says you must make a payment by a certain date to activate that agreement. And then later down further, it says, once the agreement has been activated. So I guess in the legal world, it's supportive of both. I mean, certainly if Ameren had not agreed, there'd been some confusion. They wouldn't have filed their EFIS thing indicating that they agreed that the language should be changed, which is supportive of your position that an agreement had been established, but they have the activation language in there. Activate is not a legal term of which I'm aware, but it seems to describe a condition precedent to an agreement. So I will allow you, I'm going to overrule the asked and answered objection for now, mainly because I can't off the top of my head recall whether it's been asked and answered. So I don't see any particular harm in answering it twice. But I don't know how much leeway I'm going to give you going down this road, making an argument that's already been made.
Okay.
So go ahead. Go ahead and re-ask your question.
I'll keep it off for now. Going to Exhibit 3 that I entered, rules, regulations, and tariffs. The verbiage of disconnections. And this goes into
What specifically, because for Exhibit 3, I have the commission's rules, Chapter 13 rules.
correct, yes.
You've got an area that's circled there. Are we referring to that, or are we referring to a different area?
Referring to the circled area.
Thank you. Thank you. Go on, Mr. Kelvin.
I'm missing
And you have
something.
that in front of you, Ms. Kirchmeier?
Yes, I do. Thanks, Judge.
All right.
In that verbiage that's expressed, where does it say that it excludes AMI meters for Friday disconnection, or AMI meters can be disconnected on Fridays? Where in that verbiage does it talk about how many people know that AMI meters work the way that they do?
Objection, compound question.
It's a regulation, rule, and tariff.
No, I understand. A compound question means you're essentially asking two questions bundled together. That's generally what that means. Like, did you go to the store and what did you buy there? They're two separate questions and they become easier to answer when you separate them because you can give answers that are confusing. otherwise. So why don't we break it down into, I'm going to sustain the objection. Can you ask it by asking shorter questions?
Does it have
So
any
your
verbiage
first
in there that
question, your
excludes
first
AMI
question
meetings?
is, why don't you just,
Go ahead. Hold on a second.
why don't we just, the circled portion of section 3 does not mention AMI meters at all, does it?
It does not.
Okay. Mr. Felber, go ahead.
Hold on a second. Sorry, my son had to get something.
That is fine. Go ahead.
But where in it in the language does it talk about AMI meters are excluded? And what's the what makes
No, when you hit the end, that's when you start the compound question.
Yeah.
So you were
What-
fine
what-
until then. Ask the first part.
what makes it different? Where does it state in it about AMI meters being able to be disconnected on a Friday?
I already responded to the judge and explained that AMI meters are not mentioned in the specific rule that you have circled here. I'm sorry, what, I guess you'll have to maybe ask the question again. I'm sorry.
I took a second question to be, what would make you think that this rule would not apply to AMI meters?
Okay,
Is
sure.
that the correct question, Mr. Felber?
Correct. What's that?
Okay.
Is that the question?
It is. Yes, Your Honor.
So this rule indicates that we cannot disconnect service on a day when utility personnel are not available to reconnect the customer service. So there is no need for utility personnel to reconnect customer service with AMI due to the AMI functionality. And generally, we do staff personnel on the weekend. So if there were to be a reason why the AMI reconnection could not be completed due to some type of a glitch with the, sending it electronically, there would be personnel to reconnect in those types of situations on a Saturday.
But it doesn't explain that in there. So how would a
There's-
customer know?
Well, there's nothing in that rule that indicates to me that we wouldn't be able to disconnect service for AMI meters or any, as long as we have personnel available to reconnect the customer service the next day, this rule indicates to me that we would be able to disconnect service.
You guys do disconnections for regular meters on Fridays? Outside of business?
There are times that, yes, we definitely disconnect. Are you talking about, to clarify, are you referring to non-payment disconnections? So are you asking if we perform non-payment disconnections for non-AMI meters on Fridays?
Yes.
Yes, there are situations when we do, yes.
What are those situations?
If there, to be quite honest, we oftentimes, and there may be some recent changes with AMI, but our normal course of business would be to disconnect services up until noon on Fridays and staff until noon on Saturdays, personnel that would be able to reconnect service. Now, does that happen every week? Is that currently what we're doing as of today? I can't specifically answer that. But we have been disconnecting on Fridays for quite some time.
All right. Thank you. I want to go into camera mode for the next one.
Okay, let me do. Bear with me just a minute. I'm checking to see who is currently listening to the feed and whether there is anybody I don't recognize. And it appears that everybody that is currently on this WebEx call is authorized to view this information. So we don't need to go into a breakout session, but we will go in camera. So Ms. Hefner, we'll go into camera now. We'll go in camera now. Okay. Then let's go out of in camera and go back on the main record. Okay, we're out of in camera. Go on with your next question, Mr. Felber.
Okay, so where's there any writing that states that you agree that if you set up a payment agreement where you're agreeing to waive it, wouldn't you want something worded or a guideline worded to show to the customer if there's a dispute? I mean, obviously, if a customer's in worry of being disconnected, they're going to try to establish something so that way they can, prevent the disconnection, correct?
Just as a customer who's familiar with the rules also knows that by filing a dispute, they would have their disconnection order canceled. So by setting up a payment agreement, you're agreeing that you owe that amount due and that you are requesting for assistance in paying that over installments.
Where does it state though? Where does it state anywhere in your notes that I've agreed to the charges? I mean, I would think you would want to have it written down, correct? And you would do a follow-up like you've done follow-up notes in here. You know how you guys have put things in here. I would think you would put that in there in writing so that way you're saying, hey, Mr. Felber did this, or et cetera. He's now legally binded to this. Wouldn't you want a customer service representative to follow up? How does the customer know that?
Objection argumentative and asked and answered.
Bear with me for just a second. I'm kind of thinking this through. I don't agree with the argumentative. I do agree with the asked and answered. Mr. Felber, the reason I don't always give reasons for why I make the rulings I'm making, but you guys are quibbling over how you guys are interpreting different things. She's indicating, Ms. Kirchner is indicating that that by entering into or trying to enter into a payment agreement that you are agreeing to that amount, and therefore it's not in dispute, and that if you were actually disputing it, you would be filing either an informal or formal dispute with the PSC. And the position that you are coming up from it as is that when your back's against the wall and you are trying to get your and correct me if I'm incorrect here, that if you are trying to get your power reconnected immediately, you may feel that you have to agree with something you in fact do not agree with.
Correct, Your Honor.
Okay, then it has been asked and answered, so I will sustain the objection.
Going back to something that your guys' counsel brought up, complaint number EC 2019-0121. What's the real reason why we dismissed that complaint?
Well, why don't you just ask what is the reason that the claim was dismissed before we go to any real reason?
What was the yeah, that would be fine. What's the real reason why it was dismissed?
Was this the formal complaint you filed in late 2018 that I worked on?
Regarding deposits, yes.
From my recollection, you dismissed that complaint, but I'm trying to refresh just bear with me. That was a long time ago. I know the complaint was
Because
dismissed.
to the extent this deals with dismissal, there is obviously some sort of settlement, and settlement discussions are privileged and confidential, I believe, under the commission rules.
Correct.
That is correct. That would be, but also, it's not really relevant to your current complaint. So,
What makes it relevant to the complaint is council brought it up and made it to where it sounded like it was in agreement with him when it related to a deposit that they had to remove because of overchargement or misrepresenting that.
again, this is if there was a formal finding by the commission, I think it would be fine to rely on that, but this was all part of apparently some sort of a negotiated agreement, and Mr. Keeble is absolutely correct that anything that would be a part of settlement discussions, or that would be something known only to the settling parties would be privileged and couldn't be brought into this proceeding. Now, we know the outcome of it. We know the outcome was that it was dismissed.
Okay.
So I will sustain Mr. Keeble's objection.
All right. The next one would be what is the standard rule? This goes to June 15th on the property. What is the standard role of a line technician and when encountering someone to do a disconnect, even though services were disconnected?
I'm going to ask you, that's a very vague question. Can you narrow it in a little bit more? Because I mean, that covers a lot of protocols, how they get there, what they're supposed to wear. Be specific.
When encountering a customer, what are they what identifying documentation are they supposed to be wearing at the time? How do they announce themselves?
Well, I want to clarify that this was not a service order to disconnect the meter at your location. This was a service order to disconnect at the transformer that served your home. So there was no access needed to your property. Normally, if a serviceman, a first responder, a line service worker, we have different terminology depending on where they're located. When a service worker comes to a home, if he were disconnecting the service at your meter, he would be required to knock on the door and identify himself first, and then leave a door tag after. This was a different type of service order. So that same knocking on the door would not be a requirement because he was not accessing your property. He was disconnecting at the transformer, which was not located at your property address.
So you're telling me that he did not make any access, communicate with anybody that lived at the dwelling?
I am not saying that, no.
Okay. So if he makes access and makes himself present, what kind of identifying information or badges would he have to wear? I believe Ameren has right on their website.
You've asked your question. Let her answer the question if she knows the answer.
Go ahead.
It sounded like you were starting to get into giving the answer from the website.
Okay.
Yes, so our employees would wear Ameren, they wear Ameren attire, the line service worker, the first responder. They also should have an Ameren badge around their neck, similar to what we were required to keep your Ameren badge on your person to identify yourself.
All right. paying attention to my exhibit 6 and 7.
Now you'll have to bear with me. These are a little difficult for me to pull up because I was able to get everything else, but I believe this is we've gone through this before. This was filed. This is the only way I could access. What date was this filed, Mr. Felber?
Uh, without pulling it up, believe June 15th or 16th.
I believe that's correct. I believe I remember that. Okay, I've got a number. That's not it. Sorry, bear with me, everyone. Okay, I've got it in right now as EFS 60435, but that's just a number. And you're talking about, I believe, photographs of the gentleman in red with the yellow hard hat and the gentleman in blue with the white hard hat, and they both have safety vests on. Is that correct?
Yes, Your Honor.
Okay. And so we're talking about photos of those individuals.
Correct.
We can also, I believe, get do you have Exhibit 4 in front of you, Ms. Kirchner?
Unfortunately, I'm only finding a picture of the actual truck. It's the only picture I have found so far.
When I sent them as exhibits to council, it had to go through Google Drive because of the size.
That was the problem, and that's why I have to open it from EFS, is my security measures do not allow me to do things through Google and download them to our system. So I need to find the EFS filing if we want Ms. Kirchmer to be able to reference them. And you say you believe you filed those the same day, but I don't see them going in on June 15th.
It was either June 15th or 16th. I did so many filings, I can't remember. Sorry.
Oh, is it the notice? I believe it is. Hold on just a second. This is the 16th, I believe, and yeah, there's a number of, if you go to June 16th, notice commission to amend plaint to include property damage includes both photos from Exhibit 4 as well as some additional photos, I believe. It still looks like the only ones where you can see them clearly, you can see them in the one where they have the binoculars straight on, and you can see them in the one where it looks like they are walking towards each other. near the fence line, and that would be the rusty fence that you indicated previously was not damaged by them.
Correct. That's my neighbor's property, yes.
Okay. Do you see those pictures, Ms. Kirchmeyer?
Take a look. Yes. Yes, thank you.
Okay. All right, Miss. I'm sorry it took so long to get there. Mr. Felber, you can ask your questions about those exhibits now. And that, for reference, is Exhibit 5. Is that correct?
Yes. Yes, Your Honor.
All right, go ahead and ask your question.
What identification were they displaying at the time?
Both have Ameren gear on, Ameren hard hats. They both, I can't tell from this picture, but they both would have had their badge attached. Likely, I wear mine on a lanyard around my neck. It likely is perhaps in a shirt pocket or attached to a pocket of the jeans. But like I said, I can't really tell from this particular picture where they're walking towards each other.
Did they? So you're saying they did have their badge on?
I'm saying that I cannot tell from the pictures that the picture I'm looking at right here, that they have their badge on. But I was telling you where I would assume they had them, clipped to somewhere that perhaps you can't see in the photo.
Okay, so your answer is that you cannot see their identifying badges in those pictures. Is that correct?
Yes.
Now, if a customer makes interaction with them or they do talk to a customer, would it be appropriate for them to wear an identification badge and announce themselves?
Yes.
While I understand Ameren has encroachment of utility easement, the spot where the vehicle was parked, was that part of the utility easement?
It's hard for me to determine from the pictures you provided where exactly that truck is located in relationship to our easements.
The second vehicle, which would be the one, it's just a gray vehicle. Would you agree with me that there is no markings of identification of what company is the party? Yeah, it makes sense.
I'm going to overrule the objection and allow him to answer the question. You're asking about the VW sedan?
Yes, Your Honor.
I would agree that the picture that you submitted of the that Volkswagen vehicle does not appear to have Ameren identification on it.
Don't most of your vehicles have to show some sort of, even if they use their own personal vehicle, what sort of corresponding identification, if it's a subcontract or anything, of who they either work for or subcontract for? Yes or no?
Same objection.
Overruled.
To my knowledge, in a particular situation where a supervisor is accompanying his employee for reasons of either safety or conflict resolution or basically support of the employee, that supervisor would not need to provide identification on their vehicle. That is from my understanding.
Ameren's no stranger to this against me. You guys have reached out to the police numerous times. If there was an escalation of problem, wouldn't you have wanted the police to be out there?
There was, in my opinion, there was no need to have, the supervisor did not feel a need to have the police accompany him. He was there to provide support to his line service worker.
Which brings me to my next question. What made you lead to the grounds that there was any fraud committed? Or was there any attempt that there was any fraud that was going to be committed?
You're
Yes, there
going.
was.
Okay, I'm confused. Please clarify the question for me. What fraud are we talking about? Fraud is a general, often non-legal term, so I'm not sure. You have to clarify for me.
Okay.
Just answer the question. I want to know what the question is.
Okay, so the question would be, you guys stated to read to I
What
guess
is the fraud you're referring to?
were they the access to the meter, or where they said connections or anything of that nature? Was there any registered usage to the meter of any readings that warranted grounds?
So is what you're trying to get to is there really wasn't a reason for them to be out there?
Correct. It was a general harassment purpose.
And what was your question again?
Had there been any meter readings or anything that suggested prior to them coming out that any fraud or tampering of meter or uses of electric had occurred?
And Ms. Kirchner, you had indicated yes, there were.
Yes, Your Honor. On June 14th, I was made aware that the AMI meter had been reconnected. There had been an online connect request to start service in a name other than Mr. Felber's. And the AMI, at the time, there was no block in place to prevent an online connect request from being accepted and turned on remotely. The AMI meter turned on remotely at that time. So June 14th, the service was turned on. Once I became aware that this was unauthorized use, I had mentioned in some, it might have been my testimony or maybe a clarification earlier, that we do have authorization to disconnect service without prior notification for reasons of including obstruction, which is defined as unauthorized use of service. This June 14th connect request that had been accepted online, and that AMI meter was turned on for a matter of time until I requested that the AMI meter be turned back off.
We're getting quite a bit of feedback. I don't know where it's coming from. Go ahead, we'll just see how we can muddle through it.
Okay, so on June 14th, the service had been reconnected. The AMI meter had been turned back on because there had been a connect request that had been placed online and accepted within the system. So we had the service turned back off, and to prevent any future unauthorized use or online connect requests that were accepted without investigation, that is why we had the service turned off at the transformer.
And that was to prevent anyone from activating the service online under a different name?
Correct. Without proper investigation to ensure
Okay.
that the connect request should have been accepted.
Were all the rules followed when the party applied for services? Even though there was no registered usage. I know June 14th, there wasn't because there was a generator running to the property.
No, they weren't.
Thank you. So there was no registered usage to the address, even though you say power was turned back on. So it wouldn't constitute anybody taking or utilizing service, correct?
I was actually answering your question when you asked if all of the rules had been followed when that connect request was accepted online. No, the rules were not followed. That connect request should not have happened. And there was usage on the meter that was, the service was turned on. That AMI meter was turned on.
It wasn't on. There was no usage. Do you have a usage report of it? How much usage was actually used?
I do not have that available right now, no.
Okay. I would think you would want that to show and constitute.
Objection argumentative.
You're claiming somebody used services, so then you would constitute meter tampering.
No. Hold on, Mr. Felder. I said it when anytime there's an objection, everybody. I would sustain the objection. She's answered your questions. You may not like the answers that were given, but she did answer the questions.
Hold on one second. I want to bring up something else here. I know council mentioned at any time did I go to try to make a payment on the account. How many emails were sent to you, even though they're not listed as exhibits? How many emails were sent to you and council along uploaded into EFS that I tried to work a payment agreement with you guys?
Emails from you, Mr. Felber?
Emails from me. There's even one in EFS. Council stated that.
Okay, before you turn it into a narrative, let them answer the question.
So is the question how many emails that I've received from you and in what time frame?
Between pretty much the 19th, which you wouldn't have received anything on the 19th. So it'd be the following week when I had talked to you. I guess we had talked that Friday. From that Friday through now, how many emails did you and your council get that I willed to make a payment agreement? In fact, which I would
You're
like to-
talking about Friday, May 19th, the day it was shut off, or the following Friday?
the following Fridays, Your Honor.
Okay, so we're talking about Friday. Wait, I'm going the wrong direction.
Mhm.
There we go. Yeah.
If I could stop you just for a moment, I don't need to go off the record, but I need to grab a charger. So while you're looking for that number, I'd like to do that, please.
Please go ahead.
Thank you.
May 26th.
Yeah, that's what I've got as well. Thank you.
Should I wait, Judge?
Yeah, we're gonna wait for the court reporter to get back with a charger, so we're not gonna go. I don't see any need to go off the record, but I think we'll just wait for the.
Thank you, sir. I'm back.
Okay, so how many emails were received by Ms. Kirchmeyer from you between May 26th and when?
And up to today's date, just so that way we're not backtracking. How many emails were sent between you and your counsel that I offered to make a payment agreement?
Well, I can answer for myself personally. I've received hundreds and hundreds, if not maybe close to 1,000 emails from you since May 26th. Are you asking me if you requested a payment agreement in any of those emails to me?
Yes, correct.
To be quite honest, a lot of the emails were hard to understand everything that you were asking or alleging. So I personally don't recall one right now where you said, can I have a payment agreement? Can I make this payment specifically? If you wanted to, maybe give me some more details, I might be able to answer that.
Mr. Felber, what's the relevance? Assuming the answer is in the affirmative, that you had sent numerous emails and that say one or more of those emails referenced you wanting to enter into agreement. What's the relevance of that and what is the purpose of offering that testimony?
The relevance of it would be that despite counsel's claim that I have not willingly, it shows that I had a pattern to willingly try to resolve the issue, get some sort of payment agreement established to restore the services. Such as on May 23rd, I talked to Ms. Grubbs.
Okay. Well, without you testifying, and like I said, we're going to kind of stick to asking questions. On
your paper.
Are you?
Go ahead. Sorry.
I'm going to try this, and if this is not satisfactory, let me know. Ms. Kirchmeyer, are you aware of the complainant uh, attempting to establish payment agreements with Ameren after he was disconnected?
I will say that I could agree with that to a certain extent, yes. I'm not sure if there was anything specific requested.
You
There
cannot
wouldn't have
remember
been any
specific
options.
requests. I'm sorry, I talked over you. Go ahead.
No, I'm sorry. There wouldn't have been any options available, similar to what Mr. Felber may have been requesting. So,
He may have been requesting an agreement that was not an agreement that Ameren recognizes.
yes, sir.
Okay, so the answer to the first question would be yes. You're aware that he's tried to establish payment agreements since he was disconnected. But as to whether those payments agreements would have complied with agreements done by Ameren, you don't know.
That sounds fair.
Does that answer your question, Mr. Felber?
It does, Your Honor.
Okay.
Next question. Let me get out of here and get to it. It would be, I believe, that final bill. Auto 115C. Auto pay setup and attempted payments.
Okay, and this is already admitted onto the record, and it is the response to staff's data request MPSC 0023. Go ahead and ask your question.
Is it true when establishing auto payment that Ameren, Missouri sends out a agreement letter or a letter that says you are agreeing to auto pay for customer clarification and confirmation?
I'm sorry, I'm thinking. So the question is, do we send out a confirmation letter that auto pay has been established on an account?
Correct. Yeah. Just confirming that the user set up auto pay.
I apologize. I'm honestly thinking about this. Trying to,
Take your time.
do we send a letter? I'm honestly thinking of my own personal account because I'm on auto pay and I'm trying to recall as well. Honestly, Mr. Felber, I apologize, but right now that is eluding me. Whether or not we send a confirmation letter once auto pay has been established. I believe yes, but I am not 100% certain. So I apologize without having all of my reference material in front of me to look it up.
Okay. Now, when taking off auto pay, you guys send out a letter, correct?
Once you've been removed from auto pay,
Correct.
once again, I apologize, but I'd have to, I mean, I could easily find this information if I had all of my reference materials at my disposal.
Okay. All right. Yeah. Knowing the disputes that we had on the account, when did Ameren ever reach out to, there were lots of disputes, correct? When did Ameren ever,
Is that a yes?
I would agree that there are many disputes with Mr. Felber's account, yes.
Thank you.
when did Ameren ever attempt to reach out to help resolve those issues?
I believe multiple times. There was multiple correspondence between you and our company regarding your concerns.
Wouldn't you want it listed in your report? Because there's nothing in here that shows when a dispute was filed, But you guys reached out to me, and we mainly, if anything, there was just payment agreements that kind of arreared whatever. Paying attention to the two exhibits that I listed, which was the November bill and the July bill of last year, 2022.
Is there a question?
There is a question. In April of this year, there was with the dispute in which I had presented and said I dispute my bill, and I kind of opened that up. It had to deal with the summer usage, winter usage, vice versa, and the corresponding months. Was there any attempt by any representative to reach out to me and discuss that?
If you gave me some more specifics as to the dates, I could
Are you-
probably look it up, but
Are you asking about Ameren initiated?
Correct. Yes. Ameren initiated. Any Ameren initiated where they reached out to me regarding the bill that I would dispute. For example, in the report, I have the bill from November that was due November 29th and the bill that was due July of 20, both in 2022, both which show winter usage in the summer and summer usage in the winter, in which I believe Ms. Grubbs last week on our hearing stated there's a hibernating.
And that's what you said, that's exhibit 19. If
19,
you need
yeah.
to reference that.
okay, I've got that in front of me. I've got exhibit 19 in front of me, the July and November 2022 bills. So I'm sorry, what's your specific question?
When I submitted a complaint about that, did they ever reach out to me about it?
When you submitted a complaint to who?
To your customer service team?
So if you have ever requested, so the way our customer service department does business, our goal is one call resolution. So if you are explaining to a customer service advisor that you are disputing a bill or you've got some concerns with the accuracy of a bill, that attempt should be made right then and there while you're on the phone with them to discuss that with you. If you advise that maybe you're filing a dispute, it's then, unless you have specifically asked for a supervisor to call you back, there's not going to be an attempt to call you after you get off that phone call with the advisor. It's then would be on, your action to take, whether or not you're filing a commission complaint, whether you're filing a complaint with the Attorney General's office. But unless there's any specific request on your part, and on the calls, I didn't hear any, to have someone call you back, there wouldn't be an Ameren employee reaching out to you after you were off that phone call.
So what
Now,
you're,
I'm sorry, go ahead.
no, go ahead.
I was gonna say, there were several calls. I do know that there were several calls where you did request to speak with the supervisor and a callback order was issued because the advisor maybe wasn't able to get a supervisor on at the time. So in those instances, we would call you back. A supervisor or a leader would call you back.
So would you believe that if a customer files a dispute, wouldn't it be a two-party process where both parties try to mutually work together to get to an agreement and resolve an issue? Not just one party?
I see what you're saying, and I do agree with that, but I don't think the circumstances of any of the particular times where you were advising a call center employee that you were disputing your bill, we don't set up conference calls with customers. We're just not able to do that within our call center. So like I said, the proper place for you then would be then to make a complaint with the commission or file an attorney general complaint. And then at that point, it's kind of, we're providing details directly to whomever the third party we've received the complaint from is. And then it's ultimately, there are oftentimes that it's easier than for the information that we have shared with either commission staff or the attorney general's office to share that with you directly, since they're at that point kind of taken over from that.
All right. So pretty much if you don't like the satisfaction of an agreement that both parties is just to really just go and, you know, file a complaint with the Missouri Public Service Commission is what you're saying.
We always have to offer, it's a requirement that if there is not a resolution determined between an Ameren employee and the customer, that we do offer the Public Service Commission contact information and let you know of your right to file a complaint with them. Yes.
A lot of representatives don't announce that either. But that's besides the point. Would you agree? So pertaining to those charges, I've asked numerous times on them, never got an answer or response from a representative. Would you agree some of your customer service representatives cannot give answers on those charges?
On what specific charges?
So for example, where it said summer and winter usage, and if I call and I say, hey, I don't agree with this. Why is this in here labeled as this? Why am I being charged? It's kind of misleading to the customer. When you see somebody, July's not winter, it's summer. Same thing, November, it's not summer, it's winter. So when you see those charges on there and a customer says, hey, you know, I don't agree with this. Do you see where I'm saying? Do you think some representatives can't answer that question, which needs further before you go and file a process with the Missouri Public Service Commission and raise your complaint? Do you see the point where it would say, hey, maybe a supervisor or a senior member of management needs to get in contact with somebody or get in contact with them to explain those charges?
I would agree. You know, I did listen to over 100 phone calls that you had with our employees, and I would agree that there are times that there was maybe, it was hard for you and our advisor to communicate effectively. So although sometimes I do believe that you were not giving our advisors the opportunity to fully explain things that you could understand it. But I think that that's natural in any conversation. There's a potential for, you know, a lack of ability to communicate well with each other.
But would you agree going further, like in some of your stuff? I mean, I like the report, how you guys are agreeing now to go forward and change some policies around. Do you agree that some of these implementations should have probably been done sooner than later? And especially that's dealing, you know, the history of my account. So could you agree maybe we needed somebody there that could neutralize it so it didn't get as far as what it did?
Objection asked and answered.
I'll sustain that objection.
I mean, that would really be kind of that. So would you agree? I just have a couple more questions. Would you agree there's a lot of misrepresentations and errors involved on your guys' side of the complaint that would, you know, validate why there's the complaint in front of the commission?
I don't believe that, no.
I mean, between payment agreement, I mean, you don't agree with that? I mean, my biggest in the report that Mr. Or your counsel gave back to the commission agreeing to leave, why wouldn't you focus on resolving the issue that you had in front of you before leaving and agreeing with recommendations? Why leave and do that?
Objection, relevancy. Witness is not capable of answering that question. That was a legal decision made by me.
And I asked Mr. Banks to
No, Mr. Banks is not a witness.
witness.
Trying
Okay.
to, now, give me a second, because I haven't ruled in his objection yet. I'm thinking about this. I'm gonna agree with Mr. Banks. I'm gonna sustain the objection, and the reasoning being is that Mr. Banks filed a request to respond to the staff report, and they responded agreeing with part of the staff report. What you're asking about is this hypothetical situation that you
Right.
kind of constructed, and you're asking one Ameren employee to speak in a somewhat legal capacity about whether council's move in filing that was the best or most appropriate time to address that.
Right.
So it crosses a lot of legal boundaries, and so I will sustain the objection.
Last question here that I have is would be the exhibit with the disconnect notice. May 4th, 125C.
Okay, and this is your final notice, correct?
Correct. This is the final notice. Yes, Your Honor. So something that interests me, that what you said earlier, Ms. Kirschmar, was that it shows all the ways of payment that you can pay. Now it says cash only on here, correct?
Yes.
Now you said that you can pay by certified money order or certified cashier's check, right?
Cashier's check, money order, credit card, or cash.
Okay. So where on the agreement, you said it stated all this. Where does it state that you can pay with a money order or a certified cashier's check and not a check? Well, and I understand the check portion, but where does it say? Because you stated that you can do that, but it doesn't state that on here.
I was just looking at the back real quick. So your pay now options, obviously you wouldn't be paying with a personal check on the website or the mobile app or phone. And the pay station, if you were to walk into a payment station with a personal check, the authorized payment station wouldn't accept it. They would notify you at that time that it wasn't an option.
Right. But what I'm asking is why doesn't this label certified cashier's check or money order? I don't care about the check portion. You said that it listed the options to pay by certified cashier's check and money order earlier when you were talking about this with your counsel. Nowhere on here does it say anything about having the option. It only says cash only. So if someone was wanting to make a payment, isn't it a little misrepresenting?
I don't believe so. And I don't believe it, and maybe it was misunderstood when I was explaining that earlier, but I was talking about what cash only designation meant at the top. And then I just explained that the pay now options were found at the bottom of the disconnection notice.
You also said it states all the payment options, including certified cashier's check and money order, correct?
I don't believe I stated that. And if I did, I apologize if it came across in a way other than I intended.
That would be it, Your Honor.
Okay. Thank you. It's 12:30, and I do want to take a break for lunch, but while I've got Ms. Kirchmeyer here, I have a few questions. I'll ask first, are there any commission questions at this time? I hear none. I'm going to go ahead and ask a few questions. But Ms. Kirchmeyer, your attorneys answered this question earlier last week, yet they are not, their comments are not necessarily part of the record in an evidentiary way. So would you please give me the time periods for summer and winter usage?
Sure. So our summer rates are in effect from June 1st through September 30th. And then winter rates in effect from October 1st through May 31st.
Thank you.
Mhm.
What is the standard practice when someone is disconnected, leading up to that disconnection? What customer contacts must occur, and did Ameren comply with those in Mr. Felber's case?
Yes, so we are required to send a notice of disconnection, a 10-day notice of disconnection. We are required to make 2 reminder outbound, we call them outbound collection calls to the customer, and those occurred as well. And we are, with AMI meters, we have a variance from our door knock. For non-AMR meters, there's a requirement that we knock on the door and announce ourselves prior to disconnecting the service at the meter. For AMI meters, we obtained a variance from that. So in lieu of the door knock, and this variance was so that we could do the remote connect and disconnect of the AMI meters without sending a truck out there and an employee out there. So in lieu of the door knock for AMI meters, we make a final 24-hour disconnect notification call, which was also done in this instance.
Okay. Now, you said you believed you'd received between when Mr. Felber was disconnected and today, hundreds of emails. Is that correct?
Yes, Judge.
Do you know how many calls Ameren has received from Mr. Felber as to this disconnection matter before the commission?
Good question. I don't off the top of my head. I could look through the contacts, the account contacts, which was our exhibit 102, and give you a ballpark, but I would say dozens of calls were received after the service was disconnected. But I'm sorry, I don't have that off the top of my head.
That is just fine. Trying to think. Okay, those are all my questions. Thank you,
Thank you, Judge.
and you are excused.
Thank you.
Ms. Kirchmeier. It is 12:33. Why don't we break until 1:35 for lunch? Are there any objections to doing that?
No, Your Honor.
No, Your Honor.
Okay, if everybody will be back here, well, yeah, let's go ahead and do that. I don't know how long staff is going to take, so it could be half an hour, it could be an hour, but just erring on the safe side, let's just go ahead and have lunch. So we will reconvene. We will go off the record. Okay, it is now 1:35. Is everybody present?
Yes, Your Honor.
That may be the worst way to ask that question ever. Anybody who's not present, please raise your hand. Mr. Banks, are you there?
Yes, Mr. Banks is still in the room, but I will be cross-examining the staff witness, so that's why I'm appearing on video.
That is fine. I was just trying to be sure that everybody was back before I went back on the record. I didn't want anybody to miss everything. So let's go back on the record.
Judge, before you do that, can you, I'm in a
Let's
different
stay
room
off
than
the
my,
record for a minute.
I'm in a different room than my, there she is. Okay, she's here. Never mind. Thank you, Judge. Go back on.
All right, let's go back on the record. All right, it is now 1:36. We're back on the record. Everybody's had a lunch break. We finished off Ameren's only witness last time, and it is now staff's turn to call their witness. It's my understanding that staff has one witness, and just so there's no confusion about this, let me find where I put it. There it is. I have listed in regards to staff's witness that cross-examination will be first by Ameren and then by Mr. Felber. Is that everybody's understanding?
Yes, Your Honor.
Yes,
All
Your Honor.
Okay, staff, go ahead.
Yes, thank you, Judge. The staff would call Ms. Sarah Fontaine.
Okay, Ms. Fontaine, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Okay, staff, you may question your witness.
Thank you. Ma'am, for the record, would you please state and spell your name for the record?
Sure, it's Sarah, Sarah. Last name is Fontaine, Fontaine.
And then are you the Sarah Fontaine who wrote the staff report memo in this case?
I am.
And just for your knowledge, that that report has been pre-marked as Exhibit 200, and each of the exhibits to the report have been marked as 200, Exhibit 200, and then the corresponding letter of the alphabet, A, B, C. So, was that report and the exhibits true and correct at the time that it was filed back in July, I believe it was?
Yes.
And to the best of your information, knowledge, and belief, the things stated therein still true and correct today?
Yes.
Do you need to make any changes or corrections to any of your report?
No.
Okay. Do you have a copy of it with you?
I do.
Can I get you to turn to the top of page 10? Let me know when you're there.
Okay. Okay. I'm there.
And there was some confusion about this earlier during Ms. Kretschmer's testimony, so I just wanted to clarify this one statement at the top of page 10, where you say, however, Ameren did not notify Mr. Felber by personal service or first-class mail about his default prior to his disconnection. Do you see that statement there, ma'am?
I do.
What is that statement in reference to? Can you explain that for us?
Sure. I think it's important in the staff report to read what was written before that paragraph. The reason why I stated that was because I was talking about the comparison of a pending payment agreement versus an actual payment agreement. And I think as we've covered several times so far, that there is a difference between the two. And when I offered a recommendation for Ameren to consider changing the wording on the email that goes out to customers, I was pointing out here that should it be an actual payment agreement, not a pending payment agreement, that there would be other requirements involved as far as notification and things like that. So that's why that paragraph is there.
So you aren't disputing that Ameren followed the proper notification requirements, assuming that this May 18th agreement, whatever it was, assuming that was not a payment agreement, you're not saying that Ameren messed up with the notification requirements?
No.
Okay. Also, could you explain briefly the process that you went through in the course of conducting your investigation in this case?
Sure. So when we received a formal complaint, one of the first things we do is typically when we receive a formal complaint, it's already gone through an informal complaint process with our consumer services department. So we'll go back and take a look at that. Then we'll reach out to the complainant. And once we make contact with them, we try to ask them for any information that they would like to include that maybe was not part of their formal complaint that we need to take under consideration. We also take time to kind of go over the process of what's going to happen from here, let them know if there's further information that they feel would be helpful to us during the process. They can submit it to us through email. I provide my contact information, or it can be submitted through EFIS. We also send out data requests to the company. So we kind of do a collection of any bills. I think, you've seen a lot of the data request responses throughout this, and those are stemmed off of data requests that we send out to the company. So we let the complainant know as well that that's going to be occurring. And once we receive all of that information, we can compile it, do an investigation, and then try to produce a staff report that lays out all of our findings.
All right. Judge, this is a little different than usual because the Exhibit 200 and 200A through 200F have already been received into evidence. I believe you did that on Friday. So I don't have to offer it into evidence. It's already in evidence. Just want to confirm that, first of all, and then assuming your recollection is the same as mine on that, I would tender the witness for cross-examination. Can't hear you, Judge.
Thank you very much. I was still muted. Yes, that's my recollection. I remember it was one of the first exhibits we admitted. We admitted 200 and its various attachments A through F onto the hearing record, and this I believe is confidential in its entirety. That does not make a difference at this point in time.
Thank you, Judge. I would tender the witness.
Thank you. Ameren, do you have any cross-examination questions for this witness?
Yes, Your Honor, thank you. Ms. Fontaine, as I think you mentioned on direct, it is standard procedure for staff when investigating a formal complaint against Ameren, Missouri to send Ameren, Missouri data requests, right? And is it also standard procedure for an Ameren, Missouri employee to respond to staff data requests as part of the investigation of a formal complaint? And is it, I'm sorry, I was getting feedback. Is it also standard procedure for Ameren, Missouri to provide staff a copy of account contacts, recorded calls, and copies of bills in response to data requests as part of an investigation of a formal complaint? And complainant contacted Consumer Services Division at the Commission on May 19th, 2023 to submit an informal complaint against Ameren, Missouri. Is that right?
That's what I have.
And do you have a copy of Exhibit 123C, which is that informal complaint?
I believe so.
Okay. Well, I guess, can you confirm that that is the informal complaint that the division received?
Yes.
Okay. And as part of that informal complaint, complainant informed the department that he had a payment agreement in which he agreed to pay $2,500 on May 19th instead of May 18th. Is that right?
That's correct.
And there was no reference to an alleged down payment due date of May 22nd, 2023 to activate the payment agreement as part of the informal complaint, right?
Correct.
And you have listened to the recording of the May 18th, 2023 call between Ameren, Missouri customer care reps and complainant, which was attached as Exhibit A to staff's report, but also Ameren, Missouri Exhibit 104C-D.
Yes.
And were you present in the hearing or listening in to the WebEx hearing last Friday, October 6, 2023, when the May 18th call recording was played?
It was.
So from your perspective, was it made clear to Mr. Felber during that May 18th call that the initial payment was due by the end of that day to activate the payment agreement?
I would agree that it was clear.
Were you also present during the hearing last Friday when the April 13th, 2023 and April 25th, 2023 recordings, which are exhibits 104C-A and 104C-B respectively, played?
Yes.
So based on those recordings, doesn't it appear that complainant was alleging a different due date for payment back in April as well?
Yes.
And in April, complainant identified the alleged different due date as his basis for disputing his bill then, correct?
During the April time period?
Yes, ma'am.
Yes.
If I could refer you to page 6 of staff's report, exhibit 200. Are you there, Ms. Fontaine?
Yes.
Great. If we look at the top paragraph, the first full sentence, the report states, and please follow along as I read this, 4 extensions occurred until Mr. Felber's service was ultimately disconnected on May 19th. The next time Mr. Felber stated that he wanted to dispute his bill was on May 23rd, 2023, on a May 23rd, 2023 telephone call. Did I read that correctly?
Yes.
Awesome. So with the 4 extensions after the April dispute, wasn't the alleged due date for the April payment agreement dispute resolved?
Can you repeat that for me?
Sure. With the 4 extensions after the April dispute, wasn't the alleged due date for the April payment dispute resolved at that point?
For the April dispute?
Yes, ma'am. The April dispute.
I believe it was resolved by that time.
And so your investigation revealed that Mr. Felber didn't dispute his bill following the May 4th, 2023 disconnection notice until after he was already disconnected. Is that correct?
Yes.
June 20th, 2023, staff was provided the first version of the pending payment agreement confirmation email Exhibit 8. Is that right?
I believe it was a June 20th EFIS filing.
Okay. And just so we're on the same page, if you look at page 8 of staff's report, I believe it's in the bottom section. There's a bolded heading of 20 CSR 4240-13060. So does that comport with what you just described as it was June 20th that staff received the first version of that email?
Yes.
And that email, which has been marked as Exhibit 8 by complainant and now entered into the record, that email explains that a required payment of $2,509 is needed to activate the agreement, correct? And to your knowledge, was any payment made by complainant on or before May 19th?
To my knowledge.
To your knowledge, has complainant made any payment to Ameren, Missouri that hasn't been returned since February of 2022?
Not based on information and data request responses from Ameren.
And at the time of staff issuing its report on July 24th, 2023, had complainant provided any of the other versions of the pending payment agreement confirmation email? So I think that's exhibits 9, 10, or 11 to staff.
No, the first I saw was on that June 20th EFIS filing.
Do you have a copy of exhibit 9 with you, Ms. Fontaine?
I believe so. I just want to double check. Remind me, exhibit 9, which one that was.
So it's a white background. At the very top right corner, it says 7/24/23, 2:24 p.m.
Give me just a second. Let's see if I can get that in front of me. Give me just a second. I'm going to pull it up here. That was the one that was filed on June 20th.
No, I believe exhibit 8 is what was filed on June 20th. That's what it's stamped as. Exhibit 9, I am not sure what EFIS number. I think it was actually in July.
I just want to make sure I'm looking at the right one because there was a few that were.
This is the watermark payment agreement, correct?
Yes, that's a great way to describe it, Your Honor.
Okay.
So across
That's helpful.
diagonally, the first page and second page say an Ameren mark of Ameren lied.
Okay, I do have that one in front of
Okay.
me.
Thank you. So exhibit 9 looks different than the screenshot that complainant had submitted in June and has now been marked as exhibit 8. Is that correct?
Yes.
So for example, exhibit 9 has a white background instead of the black background that was appearing on exhibit 8.
Right.
And then if we look at page 2 of that document, Ms. Fontaine,
Yes.
under that blue box, there's a series of sentences. The top one is manage your communication preferences. And then if you would go all the way down to the bottom where it says E3005, do you see that
Yes.
paragraph that I'm talking about?
Yes.
So do you have exhibit 10? And that would be the September 15th, 2023 submission, I believe.
Yes, I believe I do. I believe it's the right one.
So up in the upper right corner, it would say Friday or FRI, September 15th, 2023 at 9:22 a.m. Is that right?
Yes.
Okay. And this does not have that same watermark on it, right?
Right.
Okay. So The upper right shows that it's Brett Felber at Mr. Felber's email address, and then a no reply at twilio.com. Did you see that?
Yes.
Now, in this document, Exhibit 10, the alleged due date for the required payment is May 22nd, 2023. Is that right?
Yes.
And if we look over on the next page, the page 2 of 2 of Exhibit 10, do you see that same paragraph that we talked about where it begins with manager communication preferences, and then it goes all the way down to E3005?
Yes.
All right, so then Exhibit 11, do you have a copy of it with you, ma'am?
I believe so. Give me just 1 second. Sorry, I have a lot of.
Understood. Please take your time.
You're muted, Ms. Montague.
I saw your lips move, but I didn't hear any audio.
Yeah, you're muted, Sarah.
I don't think she's muted. I'm not getting a mute thing showed up. I think whatever may be disconnected on her. No,
I still cannot hear Ms. Fontaine.
You want to go off the record while we work this out?
I think that's a good idea. Thank you. And if we can strike the unnecessary language leading back
Can you
to.
hear me now?
Yes, sir. Oh, now she's back. Sorry about that.
So back on the record.
Yes, sir.
I'm so sorry. I'm not sure. It didn't show me as muted, so I'm not sure what that was from.
No worries. So the document that you're looking at for Exhibit 11, in the upper right-hand corner, does it show Brett Felber at Mr. Felber's email address and then a no reply at twilio.com? And then the date underneath that in the upper right area, does it say Friday, September 22nd, 2023 at 5:47 p.m.? Okay. If we flip to page 2 of Exhibit 11, you don't see underneath the blue bottom of the box, bottom of the blue box, that there's that same manage your communication preferences and the multiple sentences down to the E3005, correct? So instead, there's a blurb on the bottom of page 2 that's highlighted in yellow. Is that right?
That's right.
So has staff been able to confirm the authenticity of exhibits 9, 10, and 11?
No.
Do you have a copy of exhibit 113C, which, if it helps, is Ameren, Missouri's response to staff DR 15?
Yes.
Do you recognize exhibit 113C as the response you received to staff DR 15 in this matter?
Yes.
And in this response, Ameren, Missouri's representative, Aubrey Krishmar, lists Ameren's attempts to contact complainant in advance of the May 19th, 2023 disconnection. Is that a fair summary?
Yes.
So recognizing that complainant appears to contend that he did not receive or potentially did not receive all of those contacts listed in exhibit 113C. If Ameren, Missouri completed all of those contacts as listed in the exhibit, wouldn't Ameren, Missouri have made all required contacts on all contacts that are required under its tariffs, commission rules, et cetera, in advance of the May 19th disconnection for non-payment?
I would agree with that based on the information submitted in this.
And if I could refer you back to your report, staff's report exhibit 200 at the top of page 4 of 13. Are you there, Ms. Fontaine?
Yes.
Excellent. So during your investigation, you noted that even though the various call logs are for some of the dates, the telephone numbers and calls do not match between the logs presented. Is that right?
Correct.
Did complainant provide you with any further information or clarification of his phone logs?
No, not specifically for that.
During your investigation, Ms. Fontaine, did staff review complainant's bills for the account?
Yes.
And has staff been able to find any billing errors in those bills?
No.
And just to clarify, staff's investigation did not reveal any clear violation of applicable statutes, commission rules, or regulations, or the company's tariffs. Is that right?
That's correct. We just had a couple recommendations.
And staff has not filed any amended reports to change that conclusion. And today you didn't make any changes on direct. Is that correct?
Correct.
All right. Thank you very much for your time. I have no further questions.
Mr. Felber, do you have any questions for this witness?
I do. All right. So pertaining to the call logs that I sent from T-Mobile that show I guess with the phone number on there.
What exhibit are you referring to?
It would be in the informal, it will start out with the informal complaint process of which we did everything first.
Is this attached to staff's report or is this something else?
Yes, it is. It is attached to staff's report. Yes.
Okay.
It is exhibit.
The
Jeez,
informal complaint attached, Ms. Fontaine, or is?
I didn't hear you, Mr. Keeler. Go ahead.
I don't recall the informal complaint being actually attached. Ms. Fontaine can correct me if I'm wrong there, but.
It was not attached, I don't believe. I believe that it was offered as an exhibit by Ameren, but other than that, no. And while it was, while Attorney Grubbs questioned about it, I thought that was in relation to it as an exhibit and not as an attachment to staff's report.
Do you see the phone number that it shows directly for it?
Can
The
Mr.
phone
Grubbs, Ms. Grubbs respond whether or not it is actually attached to staff's report, since he has described it as attached to staff's report?
It was attached in the regular report as an exhibit.
I do not believe it was attached. The informal complaint that's been marked as Exhibit 123C, I don't believe it was an attachment to staff's report. There may have been a reference within the staff report to it.
That's my recollection as well. So I don't know what he's referring to when he says attachment to the report, and he calls it an informal complaint, Judge.
It shows the call logs.
Okay. Are you wanting to refer to the informal complaint, or are you wanting to refer to the call logs, or both? Because we can refer to the informal complaint, but we need to refer to it under the exhibit number that it's admitted under, because it doesn't appear
It
to
should be Exhibit 1, I believe. It was the very first exhibit log that was submitted.
The very first exhibit that was. Oh, your Exhibit 1. Okay.
Correct. Yes, Your Honor.
Okay. And if I remember right, that was there were Exhibit 1 looked like a phone screen. Is that correct?
Phone screen, and yes, it did have as well the call log from T-Mobile.
Okay, and the call log from T-Mobile,
It might have been broken into two different.
I think it was, if I remember correctly. Bear with me just a second. So we skipped ahead at one point. That's Exhibit 14, the T-Mobile call log?
Oh, yes, Your Honor.
Okay. Do you have a, Ms. Fontaine, do you have Exhibit 1, which is his, it looks like a, phone screen log,
Yes.
and Exhibit, as I said before, I believe 14, which appears to be a computer printout.
Yes, the T-Mobile logs.
Can you go through the log and find any day from May 1st? I think I provided through May 1st and May 18th that shows the complete clear log. Do you see any numbers on there that relevant to Ameren, Missouri actually reaching out to contact me?
Part of the concern that I have with these is it doesn't show full telephone numbers. So
It shows what phone calls though are on each and every day, and you would be able to see a corresponding of 1-800, or it would start off with it. Do you see any phone calls that are primarily what I'm looking at is, do you see any phone calls from T-Mobile inbound or outgoing from an Ameren phone number or phone calls of that day? The days that they claim that they called.
I'm going to object to that, because he's just, like you said, that it doesn't show the complete phone call or phone number, excuse me. So without that, how can she tell what the phone number that was calling in or calling out was?
Was there a phone call that day?
Hold on, I understand that. I think Mr. Keevil is correct there. However, if you want to, instead of saying Ameren, because the numbers are not displayed such that this can be given a good correspondence, would you rather go with, I mean, if you want to ask about 800 numbers, I think you can certainly do that.
Yeah. Does it show any 800 numbers that the days that they state that they reached out?
And what date is that?
Anywhere from the 16th through the 18th.
Based on the T-Mobile log that you provided here, your exhibit 14th. And those dates, I see one on May 18th at 8:01 a.m. that starts out with an 800 number and then a 5.
Correct. That would be their 800-552. Now, does that show as an outgoing or an incoming? Usually outgoings would be in red or green for incoming.
Don't have it in color. However, I do notice a couple up from that, it shows incoming. So based on that, I would say it's an outgoing call.
Okay. But it doesn't show anything for May 16th or May 17th that Ameren claims.
Not based on the criteria that we just covered.
All right. Where's that at right here? Next thing, as far as off of that, you were here for Miss Kirschmer's testimony this morning, right? Correct.
Yes, I was.
Did she submit any data prior to today, letting everybody know? One of the things that she said this morning that she went in, whether she said she went into her own emails or anything of that nature, and she said she played around with alteration. She admitted to the court that she admitted to alteration.
Objection, that's a mischaracterization and misstatement of Ms. Krishmar's testimony.
Not really. It shows a foundation
Mr.
basis.
Felber, there's been an objection made. I'm going to overrule your objection, Ms. Grubbs. I think I understand where he's going. You're talking about Ms. Felber. I'm sorry, Mr. Felber, you're talking about that Ms. Kirchmeyer indicated that for the purposes of investigation, she downloaded some emails and then tried to see how manipulatable those were. Is that what you're referring to?
Correct. Yes.
Okay, that's what you mean when you say altered?
Correct. Yes. Yeah.
Okay, then yeah, I'm going to overrule the objection. You can answer the question, Ms. Fontaine.
I was not aware of that prior to today.
Okay. In the terminology of the staff report, which I brought up earlier, where in the report does it say under staff that it is an actual a pending payment agreement? Where does it say on the template that they send out in their emails? Where does it say that at all?
Judge, I'm going to object to that. That's a total mischaracterization of the report, as well as what Ms. Fontaine said earlier. The report, as she explained, goes through, if you believe Ameren's position, this, if you believe Mr. Felber's position, then that, and the report itself on that section that we were looking at when she was doing direct testimony states quite clearly that the staff has submitted a data request to the company requesting a copy, and therefore it shows that we didn't have it when we did the report. So it ain't in the report if we didn't have it. He's just making whatever up that he wants to out of what is there.
Well, I don't get that impression. I feel that he may be cherry picking it for pieces that are helpful to his case. But I understand what you're saying. When you talk about that, you're basically saying at the time, I believe staff did say that whether or not a violation occurred would be largely determined by how the commission resolved conflicting evidence. And so what you're saying is that staff's report points out that there's conflicting evidence without necessarily making a judgment as to what that evidence, which evidence is correct.
Okay.
Is that correct?
Yes, Your Honor. Sorry.
No, I was asking Mr. Keeble. Is that what we're getting to?
Well, it sounded to me like he was saying that staff's report says that the Ameren has a template that says X, Y, Z or whatever. And like I said, the quoted portion top of page 10 clearly says at the time of the report, staff had in submission to Ameren a data request regarding template, but we didn't have a template at the time. So for him to ask where in the report our example of the template is a complete mischaracterization of what it said.
Okay, that would be absolutely right, and I would agree with that. That's not the question I heard him ask. Maybe I misheard. I thought his question was, where in staff's report does it say that it's a pending payment agreement?
Correct.
Is that your question? Or
That was my
or
question.
Mr.
Yeah.
Evil more?
That was the question. Yes. Where does it say in the agreement exhibits that I presented, or even the original JPEG that was submitted? Where does it say pending payment agreement?
Were all those items available? I know the 20th one was. Yeah, all those items were available. Yeah, you can answer that question.
I want
Is
to
there
make,
any? Go ahead, I interrupted.
okay. So I wanted to make sure I understood. So you're asking in the staff report where I addressed about a pending payment agreement? Is that correct?
I'm asking you in the submitted documents.
Let me, and if you don't like, did staff ever make a determination as to whether there was a pending agreement or an agreement?
I think what I mentioned in the report was that there was some differing things out there as far as what is considered pending, a pending payment agreement versus an actual payment agreement. What I will say is, based on all the information that I received from Ameren, as far as the past payment agreements that have been set up versus payment agreements that have been offered to Mr. Felber, it is clear based on that there is a difference between a pending payment agreement and an actual payment agreement. So that would be my answer for that.
Okay, thank you. I appreciate that. May 18th, this audio that surrounds everything, you were listening to that. Can you explain, can you explain where you ever heard what date of the payment, what time of the payment, when it had to be? We do hear that the payment was eventually, whatever, it would agreed, but was there a date, how much the amount was, and the date of the payment agreement, and when the date of the payment agreement had to be exhibited, and when, or not exhibited, but when it had to be due? Is there any date that specifies May 18th, etc.? In that tape that was played on Friday, is there anything in there conclusively that says you agree to this amount on this date at this, correct?
So when I put in a data request for all recorded phone calls, I received a list back from Ameren of over 100 phone calls, and each of those have a date associated with them. So that's what I would conclude based on the dates that were provided, that phone call occurred on May 18th. And it says within that phone call that the payment is required today. So that's what I took that from, was that list that was provided to me.
But what I'm asking you, it doesn't say that it's due on May 18th, correct? Nowhere does it state the amount that's due or any of that nature, correct?
You're speaking about the phone call specifically?
Yes, ma'am. I'm speaking about the phone call specifically.
And for clarification, I believe we're talking about confidential exhibit 104D.
Yes.
I would agree that during the phone call, it does not specifically say May 18th.
Okay. Thank you. All right. Let me go on to, I guess, the exhibits that Ameren submitted. Let me get into here, sorry. It would be in any exhibits pertaining to any billing, I like the notes that are put in here. These are great notes. They're wonderful notes. However, I'm missing notes in the first set
Wait,
of
wait, 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 wait.
exhibits.
You've jumped ahead and you haven't told me what you're talking about. What's the document you're looking at? I can't look at notes if I don't know what document I'm looking at.
It would be their first set of, it would be right under the complaint, the actual original complaint that was filed. It would start with page 1, 1253. It would show my account number and everything. They have highlights and everything to them.
Hold on just a second. And this was attached to staff's report?
No, this was actually from the
Ameren?
Ameren report. Correct. Here, let me, I don't think
Did you have an exhibit number?
I do have an exhibit number. I didn't save it as a download. I just kept it in email. Let me get it for you. It would be, I believe, yes, 102C, all field notes.
Okay, yeah, all right. Ms. Fontaine, do you have a copy of that?
All right. So they're great notes, no doubt about. However, where in those notes do you see if there was any billing issue or explanation that was needed? Where do you see anything that was actually inserted by Ameren or any of the representatives that said, minus the venting or anything of that, where they reached out, if I had a dispute, where they reached out to try to mutually resolve any billing dispute with me?
Talking about in the full, like 5 years of notes that are here, or anything specific, or?
Yeah, Judge, I'm going to object to that, given the volume of the notes. They're in the record. They speak for themselves. Everybody can read them as exhibit whatever they are. I don't think Ms. Fontaine should have to sit there for the next hour and a half and read through whatever number of notes Mr. Felber wants her to read through.
Okay,
They
so
speak for
any,
themselves.
okay, well then if I go down to,
Let me, Mr. Filber, let me ask you this, because there's been an objection made. Is there a particular note you want to refer to, or are you referring to the notes as a whole?
their notes and complaints, any complaint that was filed, do they see anything interactively when they were skimming through the notes that shows Ameren reached out to explain this is why this dispute, or mutually bind it into anything of saying, hey, we've tried to resolve this with the customer?
Ms. Fontaine, based on the best of your recollection, do you recall any evidence that at any point during this current complaint process dating to a few days before May 18th, 2023 until now, do you recall any points at which Ameren reached out to Mr. Felber to try and resolve things?
So I didn't see in the account notes, which is what we're looking at right now. I did not see that in there. However, I will say, based on recorded telephone calls that I listened to, they did respond to Mr. Felber about complaints or disputes that he had in the telephone calls.
Okay, I think that's sufficient. On the basis of that, I'm going to overrule your objection, Mr. Keeble.
Okay.
One second, I think I had. All right, so going to Ameren's logs, did they provide you any copies of actual? I know they use a outside vendor, broadcast company, and everything. Let me go into which exhibit it is. It would be the. Sorry, there's just a lot of account notes to feed through.
Take your time, Mr. Felber.
It would be in NOMP MPSC 0008.
Okay, that is, you're talking about Exhibit 108C.
Yes, yes, Your Honor.
Okay, I don't believe that's been admitted onto the hearing record.
Oh, it wasn't?
Not according to me.
That's consistent with my understanding as well.
Okay, it wasn't admitted.
Is Ameren wanting that admitted or no?
He had not planned on it, but I don't believe we have any objection to it either.
You have no objection to it?
If you want to offer it, we would not object.
Do you want to do that, Mr. Felber? If you would like to talk about the exhibit specifically with the, I mean, you can talk about, I think you can probably ask questions based on it, but if you want to ask questions based on it and have the exhibit for reference, it will have to be admitted onto the record.
Just the questions I would like to ask on it. Did you notice any discrepancies that were actually on the exhibit on page 2? For example, you go into the phone.
Now you're referring to it as an exhibit, and you're asking questions with particularity about what it says rather than more general questions. If that's the case, then I think it probably ought to be admitted onto the record to discuss. So any objections to admitting 108C onto the hearing record?
Let me look at it more closely.
Please take your time.
Go ahead.
I'm waiting for Mr. Peeble to tell me that he's had an opportunity to look at it,
Look at it.
to see if he has any objections he wants to make.
108. Let's go to okay. No, that's okay. Go ahead.
All right.
Wait, hold on a second.
Sorry.
So, Mr. Felber, you're offering Exhibit 108C?
Yes, yes, Your Honor.
Exhibit 108C is admitted onto the hearing record.
All right. So this exhibit, so what they sent you right here is a batch. There's a blank, and I would assume they left it blank for whatever purposes. It doesn't have the letter type, return phone, etc. However, they say the time that it was done was at 1:16:32. There's different things right here. However, if you go up to the top where it says 5:18,
we're looking at page 2 of this exhibit, right?
Yes, Your Honor.
Okay.
And
this is these are the
series
fields, and in the name it says batch, correct?
Correct. Yes, Your Honor.
Okay. I just want to clarify what page we're looking at so there's no confusion later. And Ms. Fontaine, do you have that up?
I do.
Okay, go ahead, Mr. Felber. I'm sorry to interrupt.
That's all right. So it says on all these things here, 518, that, and I use a vendor just like Message Broadcast as well too for one of my businesses. Great company. They are probably better than, and I'm not trying to avert off, they're a very good company. However, I do know they give you the initial time that the phone call was made. Up here it says 1:15 p.m. the phone call, and that they start it by the time they batch that out. However, down in these other fields shows the batched phone calls were not batched out at this 1:15 p.m. time, and the SMS was batched at 1:16.
Point me to where, please?
Right here in account communication history.
Mm-hmm.
Right here, it shows answer machine on 5:16, but it shows SMS and SMS. It doesn't show an actual phone call was delivered at 1:15, and more or less merely there was a SMS that was sent at 1:16. Is this, did they provide any other accurate log that shows a detail instead of a profile build of my account?
And there's the question.
I'm trying to recall. I know there was some other data request responses about contacts that were made prior to disconnection. So I'm not sure if I fully recall all of that. So I'm not sure if they did or not.
I would think they would have it under the account and the customer, the care tool of everything. I would think they would be wanting to show a history that shows, hey, we did this is this. It almost looks like, would you agree with me? It almost looks like somebody typed in a date right here, but they left sufficient information out that shows, that contradicts that own piece of paper. And how do we know that this is Mesh's broadcast?
Judge, I'm going to object to that. It sounds to me like he's testifying again rather than asking questions of Ms. Fontaine.
That's fine. That's perfectly fine. We get the point where I'm asked, I guess, what I was asking, correct?
Why don't we nail it down? Because I want to see, we got to where I saw there was a question and then we kind of did a wide loop away from it.
This actually does not show an actual call history that was labeled out. And if there's any call history that was labeled out, right here in the right hand, it says 1:15, but then there's 2 SMSs at 1:16, not the time that they're describing that they placed the call. So what message broadcast does when you send out a big...
Okay. Yeah, again, you're testifying here. We need to stick to questions at this point.
I know.
So what's the question that's in here? The question is, did staff take this to be a complete call log? Is that the question?
Correct, yes.
So I'm definitely not an expert on the message broadcast. That might be a better question for Ameren. I think I'm not sure what all is typically included, on this 518 batch process.
Well, look, if you look at, if I look at the bottom, and if I'm correct, it says one of total 10 pages, correct?
That's correct.
So that would indicate there's substantially more there. But what you're telling me is this is not a program you're familiar with and you can't speak to it being a complete call log. Is that correct?
That's correct.
Okay.
Well, Judge, it's answering the question that was asked in the data request. Data request didn't ask for give us a complete call log. Data request said, please provide the documentation showing Ameren made attempts to contact the complainant prior to disconnection on May 19th, 2023. That's what this is in response to. I mean, it's shown right there on the Exhibit 108C itself, what the question was. So, I mean, you have to, when you're looking at responses, you have to look at the responses in relation to the question to which they are supposedly responding in order to understand what they are.
I would agree with that to understand what they're responding to. And I would also agree that oftentimes there's inadvertent information that is useful to other questions that may not have been asked by staff. In this case, I see what Mr. Felber is trying to ask. I just don't see it as complete enough to give a meaningful answer. And Ms. Fontaine has indicated that she's not familiar with their messaging system, so I don't think she's qualified to ask. So I think we can end that line of questioning there. I didn't hear an objection. I can't remember, Mr. Keeble, if you made an objection or whether you were just bringing something to my attention there. But yeah, I would agree that the information was compiled to respond to a particular question asked by the staff of the commission.
Okay, that's good enough.
And then my last one would go under it's under number MPSC 0027.
All right. And that is Exhibit 119C.
Yes, Your Honor.
And that has been admitted onto the hearing record already. And this is just for the information of record. This is in response to the payment agreement, correct?
Correct, yes.
Okay, go ahead with your questions.
What number
Notice,
were you on the, Judge, again, what exhibit number are you on?
I'm on exhibit 119C,
19,
which
okay.
is,
Thank-
staff data request 27. And I think this goes directly to, it looks like the question concerns the May 22nd, 2023 due date.
correct, Your Honor. You want me to go ahead?
Yes, you may ask your question.
Something in, I guess, a data request that you could have asked, because Ameren says it's a pending payment agreement and it's a payment agreement. If you look down on contact type, it says pending payment agreement. Was Ameren ever questioned on why it's kind of conflicting in that system of it?
I think that it's my understanding that Ameren believes that pending payment agreements are what they are before someone has actually made the down payment required in order for it to actually become a full payment agreement.
Okay.
So again, I can't speak for Ameren and you know what the different types are there, but I would say this would be something that would go in a situation where they've offered a payment agreement, but the down payment hasn't been received yet.
Okay. All right. And then on the other part of it, I'll ask, did anybody in the IT, when the documents get sent into you guys, do you guys have anybody in the IT department that internally, like, for example, when they coded all this in on the page 2 of everything, what shows this, does anybody from IT look at it and see if there's any indiscrepancies, such as we have my primary email address in it, but Ameren doesn't even have their own email address in it. So there would have been no way the email would have came out. It would have been bounced back because there was an invalid field. Do you guys have anybody there with the Public Service Commission that actually overviews stuff like this? Or not really? I mean,
Not to my knowledge.
okay. All right. And can you confirm if this is a SendGrid copy or is this, I mean, who can you authenticate that this is from SendGrid or not?
No, I'm like I said, I can only go off of what they submitted in their response here.
All right. Okay. I believe that'd be pretty much it. I appreciate it.
Okay. Are there any commission questions at this point? I hear none. I have a few questions, and then I'll give an opportunity for any redirect or questions based upon. In regards to is Ameren, to your knowledge, the only utility that requires a payment to activate a payment agreement?
Not to my knowledge. I believe that that's the case for other utilities as well.
Now, in staff's report somewhere where it says that whether or not there's a violation, it's largely dependent on how the commission resolves conflicting evidence. What conflicting evidence with particularity was staff referring to?
In regards to whether it should be considered a payment agreement versus a pending payment agreement?
Is that the conflicting evidence? Is that?
I think that
It just said staff's, I believe it just said whether or not a violation has occurred largely depends on how the commission resolves conflicting evidence. Is that the conflicting evidence that staff was referring to around the payment agreement?
right. Yeah, I think what was conflicting was what Mr. Felber submitted for the payment agreement with that due date versus what was submitted by Ameren for their due date. That was the.
Okay. To ask you a hypothetical, if Mr. Felber gets on the phone with Ameren on May 18th and they reach an agreement and he's told on the phone call on the 18th that he has to make a payment that day. And then later that same day, he receives an email, and let's say that email says that he is to make a payment on 5/22. And in either event, it's to activate the agreement. If that's the case, if evidentially that's what happens, does staff have a view on whether or not a violation occurred?
Judge, are you asking Ms. Fontaine the legal effect of the hypothetical that you have posed, or are you just simply asking have staff, to Ms. Fontaine's knowledge, run into that situation or something similar previously with regard to another customer? Because with all due respect, I don't.
Probably asking the one I shouldn't ask is the correct answer there. So give me a second and think if there's a different way of doing this. But I would agree. So you're good. You're saying, am I asking staff for their legal conclusions so that I don't have to make my own?
Well,
and the answer is no. I was trying to probe staff's opinion because that's what we do in recommendations is ask, whether or not staff has an opinion on this. And oftentimes they'll put it forth. And this time they said, well, it depends largely on this evidentiary setup and laying out that evidentiary setup. But I will withdraw my question. I don't have any problem doing that. I think that's probably appropriate. So your objection is sustained. Is staff of the view that this is a pending agreement and not an agreement? And is staff of the view that it is a pending agreement and not an agreement until the initial amount is paid?
Yes.
Okay, those are all the questions I have. Is there any redirect from staff?
very briefly, Judge. Ms. Fontaine, if I could have you look at, I believe it was Exhibit 108C that Mr. Felber asked you about. Actually, I believe Mr. Felber wound up offering it as his exhibit, even though it was initially provided as an Ameren exhibit. Do you have 108C?
Yeah, let me get to it real quick.
Sure. Actually, Ms. Felber, I misspoke. Before he was asking you about 108C, he was asking you about Exhibit 1 and Exhibit 14 from Ameren. Do you have those?
And I think you mean Ms. Fontaine.
I'm sorry, yes, Ms. Fontaine.
It was Exhibits 1 and 14 of Mr. Felber, or?
No, yes, they were Mr. Felber's. Those were Mr. Felber's exhibits, and they were basically the call logs. I objected to one about because the complete number wasn't there. You remember that?
Yes.
Okay. Now, if you look at on those call logs of Mr. Felber's on Exhibit 1 and 14, do those show any text messages or those just phone voice calls?
It would show
Okay,
any
you tell.
data.
I believe those are just telephone calls.
If it shows up as a data, it would say data.
Mr. Felber, nobody has a question for you at this point.
Oh, I'm sorry.
Thank you.
Okay, now, Ms. Fontaine, if I can have you flip back to the exhibits which were initially sent in by Ameren, but it's 108C, I believe, from Ameren. Now this is under there's those 2 pages, those first 2 pages, the ones that Mr. Felber was asking you about. Said page 1 of 2, and then page 2 of 2.
Yes.
And then if you keep scrolling through or keep flipping through the pages, though, although it doesn't say a page number at the bottom of the page, the next sheet of paper also says Exhibit 108C. You see that?
Okay.
And do you see on that page in the upper right-hand corner, it says confidential, and then it has a commission rule number. And over on the left margin, up at the top, it says customer number, which I won't read, and then says status, answering machine, sent date, May 16, 2023, 1:01 p.m. You see where I am?
Yes.
Okay, now that paragraph under the sent date, what is this sheet of paper?
My understanding is this is the message that is played whenever these phone calls are sent out by Ameren to notify the customer that they're up for disconnection.
Okay, so this is the notice that was sent by Ameren, telephone notice that was sent by Ameren that disconnection was imminent. Is that correct?
Correct.
And go to the next page. There's another similar document dated May 18th. You see that?
Yes.
Is that also a disconnection notice that's played when they get the answering machine?
I think it's whether they get an answer or it goes to an answering machine. I believe this is the message that comes through.
Okay, this is the auto message, the robo message, or whatever you want to call it, that is played for the disconnection notice.
Yes.
Okay. Mr. Felber was also asking you some questions about when staff receives a response to data requests, does staff have the IT department, I assume the staff IT department, look at those responses to see how they're coded or something along that nature? Do you recall that line of questioning?
Yes.
Now, is it true that when staff receives DR response, when I say DR, you understand that to mean data requests, correct?
Yes, I do.
Okay. When staff receives DR responses, it receives those through its what we call the EFIS system.
Yes.
And that the manner in which responses are submitted into EFIS is governed by EFIS, correct?
Yes.
So, I mean, if Ameren wanted to recode something, it couldn't it would have to do it before it tried to submit it into EFS, correct?
I believe so.
In other words, they couldn't, Ameren or any utility, I'm not picking on Ameren here, or Mr. I'm not picking on anyone, but anyone who wanted to recode something before they submitted it into EFS as a data request, I mean, they couldn't just recode EFS to make it appear the way they wanted it to, correct?
I don't believe so, no.
Okay. Going back to the exhibit 108C, Ms. Fontaine, what was the question in which staff received this response? Or do you remember?
I've got it here. Give me just a second. So there were several parts. The first was, please provide the documentation showing Ameren made attempts to contact the complainant prior to disconnection on May 19th, 2023. The second was, what system or program does Ameren use to make phone calls to its customers? Third was, how does that system or program document phone calls and interact with the company's telephone provider? And the last was, what is the telephone number that a customer may see displayed on their phone when Ameren is calling to advise a customer of a proposed discontinuance?
All right. And if you go back to the first response, be the first sheet of Exhibit 108C, does Ameren have, on that sheet, do they state that the answering machine was reached twice and that the on 5/16 and then on 5/18 the 24-hour disconnect call was made?
So it does show that, yes, it looks like answering machine was reached twice on 5/16. And then it looks like on 5/18, the 24-hour disconnect call was made and there was a live answer.
All right. All right. I think that's all the questions I have, Judge. Thank you.
Thank you. Any final questions, Mr. Felber, based upon commission bench questions and redirect?
No, Your Honor.
Ameren?
No, Your Honor. Thank you.
Ms. Fontaine, I have no further questions. You may step down. Thank you very much.
Thank you.
As I indicated before, I am not going to be ordering briefs. And in lieu of that, I'm going to allow each party to make a short closing statement, should they so choose. Similar to openings, it's just basically, while closing statements are not actually evidence, they may, in fact, give the commission an eye as to how you see the evidence being in your relative favor and why you think that the commission should rule for your particular party. With that in mind, Mr. Felber, you have the burden in this case. It's your burden to show that you are more than likely that it is more than likely that that Ameren committed violations of the commission's rules, tariffs, et cetera. So with that in mind, you can make your closing statement.
All right, thank you. First and foremost, I want to thank the commission and everybody for being here today to hear my complaint and the surrounding details of my complaint. 144 days of disconnected service is no fun. While I have put unorthodox stuff in, requested a demand. I believe I have shown 100% that I've taken the effort to try to work things out with Ameren, Missouri. Unfortunately, they have, during the course of it, denied that opportunity. I believe and trust what I have given in my complaint is accurate details, which accurately pinpoints in which Ameren abused the payment agreement process, illegally disconnected services, and under their own admission in the staff report admitted, failed to mail a disconnect letter. Something else I'm going to point out that I didn't already have typed up, but I brought it up while I was actually on lunch break. At the beginning of today, when we were going over the evidentiary hearing, Mrs. Kirschmeyer, the regulatory department, admitted that she personally went into emails, whether they were her own emails for discovery or any nature of that, explored, altered documents to see how the process works and how it is done. So she has clearly admitted in filing right here in front of the commissioners and the staff and in front of her own counsel that whether she says they're her own emails, how do we not know that Ameren, since they've already admitted to alteration, has gone in here to some of these documents that they have supplied or failed to supply and edited or altered their images to try to make their case look better. Anytime I try to reach out to Ameren, Missouri to make a complaint or try to agree to a process, here's exactly what happened. I had false police reports made against me. I had false police reports made against me by Ameren, Missouri and their counsel. I will not say his name. He knows who he is. In hopes to get me arrested. These are scare tactics that they've also done in 2011 against me. And they tried to do in 2018 and almost in 2023 to my business. But in each one, those government officers took down all the supplying information and went along their way. Those officers could have spent more time dealing with actual real crimes that were occurring.
Objection, this is so far beyond the scope of the complaint and any
guys did it.
testimony that's been provided. This is irrelevant and argumentative. Thank you.
It explains what you guys have gone through.
Hold on. Thank you, Ms. Grubbs. I'm going to overrule your objection and allow Mr. Felber to continue.
They have not been satisfied with each agreement that I have given that contradicts everything that they have stated. They've offered mere excuses throughout the whole process and prior to the process. I have emailed them to try to go ahead and make resolutions, and they have failed to respond. They also have what's in big is a manipulating turn of how they can utilize a system when in a payment agreement compared to pending a payment agreement. This allows them to manipulate, even though it's written by their own party and their advertising companies, how they have it designed in a way to manipulate how they disconnect services. I was led upon the assumption during my informal complaint that if I sent over my call logs, that Ameren was going to go ahead and restore services. I was told on the formal side to send that. As a usual tactic, Ameren went into their ghost mode where they failed to respond back, which then I was told to move forward and file a formal complaint with them. Ameren even states in page 10 of his staff report that they failed to send out a disconnect notice, certify that, or any of it. They have spent so much time trying to cover up the main subject agreement of this that in their own reports and statings, they've admitted other omissions and errors, such as on page 10 with failing to send out a disconnect letter. It's up to the commission and the Honorable Judge Clark to take what's factual and what's non-factual. You have a copy of a phone call record from T-Mobile, pictures of technicians not wearing their badges and failing to follow statutes within the access demand letter, several copies of payment agreements. We didn't talk much about the medical hardship, but there was an email that was listed in there. I ordered to set up a conference call between the parties to offer them SendGrid's information in Twilio, in which they declined to. They misused government agencies to have me arrested, so I would drop my complaint, as compared to showing spreadsheets of how they utilize a program and make an excuse for a payment agreement, which in all is a pending payment agreement. In all actuality, on any wording, it's an actual payment agreement. And those aren't my words. Those are the words. You see Ameren's email address on each and every single one of those documents. And then on top of that, again, as I'll reiterate, Mrs. Kirschmeyer admitted the first thing when she said this morning, she went in for investigative discovery purposes to alter emails. Right there is admitting that you have gone on to try to find ways. Now we can't trust really anything that they have given. How do we not know any of the exhibits or documents they have requested have been altered under her own admission because they wanted to see how alteration works? This is a company that abused the process, and it's up to you guys, but 144 days, it's hard to being the way you are. You have to stay strong in everything, and I hope everybody that is here listening to this today can understand everything that has gone on. Nobody should be without service for 144 days, let alone it's the only provider that gives service in the area. However, the provider does not puts the responsibility on the burden of the customer, even when the customer wants to come to a resolution. In their reports, they didn't offer any resolution to the billing. The closest that we got to it was Miss Grubbs last Friday when she said there's a hibernating period. Nobody through customer service offered those explanations. Nobody through customer service, not even regulatory prior to that. Should I have to deal with inaccuracies for 144 days, and then on top of here, that the respondents sat there altering documentation. We cannot, at this point, that's disturbing to me, to find out with all the claims they based against me. However, they've sat here for 144 days, which in all terms could have possibly altered numerous of their own documents under their own admission. I appreciate, again, being able to take the time to give this, and I hope the commission and the Honorable Judge Clark take time to review this and agree with me, the complainant, and see that violations did occur and that Ameren is able to restore services. Thank you.
Thank you, Mr. Felber. Would Ameren like to make a closing statement?
Yes, thank you so much, Your Honor. May it please the commission. You know, this has been a longer than expected hearing, so Ameren, Missouri really appreciates the opportunity to present this closing argument to summarize the evidence that's been presented over the last 2 days of hearing. And the overall headline for all the evidence presented is that after numerous attempts to work with the complainant, wherein multiple payment extensions were granted and never paid, Ameren, Missouri disconnected service to the property for non-payment in accordance with applicable statutes, commission rules, orders, and Ameren, Missouri's approved tariffs on May 19th, 2023. And I'll try to proceed chronologically and issue by issue through the evidence in summary. So As Ms. Krishmar explained in direct testimony when discussing Exhibit 107C, over the last few years, Ameren, Missouri entered into count them, six deferred payment agreements with complainant. The most recent one was entered into in September of 2022. During the cross-examination of complainant by Ameren, Missouri's counsel on Friday, 2 call recordings were played. One from April 13th, 2023, and one from April 25th, 2023. The April 13th call clearly explained that complainant had a payment extension until April 24th. Yet in the April 25th call, the complainant was alleging at one point that the extension was until April 25th, and then at another point that the extension was until April 26th. During that April 25th call, though, when asked to provide the supposed confirmation email to Ameren, Missouri with a different due date, the complainant refused to provide it. So you see, the complainant trying to allege a different due date for a payment is not unique to this May 18th pending payment agreement. Let's talk about disputing of the bill. Company witness Ms. Krishmar discussed Exhibit 114C on direct examination, which shows the multiple times since 2018 that complainant disputed his bill. On cross-examination, staff witness Fontaine explained that although complainant had disputed his bill due to the alleged extended payment due date in April of 2023, complainant did not dispute his bill after receiving the May 4th notice of potential disconnection for non-payment, and then before service was disconnected for non-payment on May 19th, 2022. During the direct examination of complainant on Exhibit 19, it was clarified that the 2 bills complainant has alleged are incorrectly calculated were actually just seasonal straddle or transition bills covering both summer and winter usage. Furthermore, Ms. Krishmar explained on direct examination when describing Exhibit 112C that no balances or amounts were transferred into complainant's account that would have been subject to the complainant's 2018 bankruptcy petition. So let's move on to the advanced notifications of potential disconnection for non-payment. Company witness Ms. Krishmar explained Exhibit 113C, which details Ameren's attempts to contact complainant about the potential disconnection. Those attempts included the May 4th, 2023 notice of potential disconnection on or after May 16th, 2023, which is also Exhibit 125C, the May 5th text message, 2 calls made to complainant's phone number on the account on May 16th, one in the morning, one in the afternoon, wherein the answering machine was reached both times. And then the May 18th 24-hour advanced disconnection call where a live answer was received. Staff witness Ms. Fontaine confirmed that if Ameren, Missouri completed the contacts that are listed in Exhibit 113C, Ameren, Missouri would have made all the contact attempts that are required under its tariffs and commission rules in advance of that May 19th disconnection for non-payment. Let's shift to the payment agreement. During cross-examination of complainant by Ameren, Missouri counsel, we heard the May 18th, 2023 call recording, wherein complainant was plainly told that the payment of $2,509 was due by the end of that day to activate the payment agreement. That, of course, was Exhibit 104C-D. That verbal exchange was the offer of a payment agreement, but it was clear that the payment agreement would not be activated until the down payment was paid. Ms. Krishmar explained that the data sent to Ameren's communications vendor, SendGrid, to ultimately be incorporated into the pending payment agreement confirmation email, showed that the due date for the required down payment was May 18th, 2018. Consistent with both the May 18th call recording in Exhibit 104C-D and further consistent with the account contact entered on May 18th as set out in Exhibit 102C. Complainant admitted during cross-examination that he never made the required $2,509 payment. Accordingly, service to the property was disconnected at the meter on May 19th, 2023. Complainant confirmed when questioned by the judge on Friday that he got a generator instead of making any payment towards Ameren, Missouri's bill, or the bill he owed to Ameren, Missouri. Exhibit 123C shows the informal complaint that was submitted by complainant on May 19th, 2023. In that informal complaint, Mr. Felber stated he had made a payment arrangement to pay $2,500 on May 19th. There was no mention of the down payment being due on May 22nd. Exhibit 101C is that original formal complaint that Mr. Felber filed. And it, again, has no suggestion of a down payment being due on May 22nd, 2023. Rather, almost a month later, as complainant described on a direct examination, he was browsing down in his email and allegedly found what's now been presented as Exhibit 8. As Ms. Krishmar explained on direct examination, the company questions the authenticity of the multiple versions of what complainant calls the payment agreement and what the company refers to as the pending payment agreement confirmation email, because they are inconsistent. Those multiple versions are inconsistent with the May 18th call recording and the other records presented. And Ms. Krishmar even explained her own experience with how easy it is to alter emails. And that has been completely mischaracterized by Mr. Felber in his closing statement. There was never any discussion of her going in and trying to alter any of the documents in this case. She repeatedly explained or qualified that she did it for her own investigation purposes, to learn how, and was surprised at how easy it was. The proper framing, though, for this confirmation email it is actually that it was a courtesy email, right? That by the complainant's own admission, he didn't find until a month later. The actual crucial piece of evidence here is the May 18th call recording. And similar to the complainant's attempts to allege a discrepancy between the due date he was given for his April 2023 required extended payment, complainant in his informal and formal complaints alleged one day later after the call recording shows that the required due date or down payment would have been due. So let's shift then to the property damage. Ms. Krishmar in direct examination explains the various attempts after the May 19th disconnection to cancel the account or restart service at the property, which is set out in detail in Exhibit 116C. Ms. Krishmar explained the multiple orders that complainant attempted to execute online and referred to them as stacked orders. Accordingly, Ms. Krishmar explained the reason Ameren, Missouri disconnected service instead at the nearby pad mount transformer a couple of houses away was to avoid obstruction, as referenced in Exhibit 117C. Ms. Krishmar further explained that no company personnel entered the property, and in fact, one of the Ameren personnel used binoculars to confirm that the meter was not registering any usage. Contrast now Mr. Felber's testimony with his son Dylan Felber's testimony on the alleged fence damage. On direct, Mr. Felber described how allegedly an Ameren personnel jumped onto the fence, but then realizing the dogs were on the other side of it, jumped back. Dylan Felber, however, described the Ameren personnel as trying to lift his leg over the fence, but then pulling the leg back. None of the complainant's exhibits or pictures show the alleged touching of the fence, and there is further conflicting information from complainant's own witnesses. Nevertheless, the company agrees with staff that the commission does not have jurisdiction over alleged property damage here. And, complainant has gone to great lengths to try to get service restored in other names. Complainant claims to have not lived at the property after May 19th, yet the complainant and his wife both acknowledged that the property address is listed as the official address for two of their LLCs, limited liability companies, which they're co-organizers of. That's Dividend Park Property Investors LLC and Consumer Energy Concept Solutions, LLC. And that second LLC, the Consumer Energy Concept Solutions, it was formed just in July of this year. During cross-examination, complainant even admitted that he called in to Ameren, Missouri as Scrappy Lacholo based on, I believe, a Scooby-Doo reference to get service started in the Dividend Park Property Investors LLC's name. Yet complainant also acknowledged that the property is actually owned by his parents' trust. Let's move over quickly to the credit and debit card attempted transactions. Complainant alleged that 2 attempts to draw funds from his credit or debit cards were unsuccessful in late May of 2023. As Ms. Krishmar described in discussion of Exhibit 115C, there were 2 separate login attempts logins to the user ID associated with Mr. Felber's account through a mobile device on May 25th, and both of those failed authorization. Here again, though, the company agrees with staff that such credit card attempt or alleged fraud, that is not jurisdictional to the commission. Moving then to the medical hardship extension. First, I think it's important to acknowledge that it's an extension, right? It's not a way to never pay one's bill. Ms. Krishmar described during direct testimony the medical hardship extension process and then Exhibit 118C. Complainant witness Dylan Felber even confirmed that Mr. Felber was told a medical hardship extension was not available after disconnection had already been completed on May 19th, 2023. And the required medical professional correspondence was not received to or by Ameren, Missouri's special fax line in advance of disconnection. So where does this really leave us? When questioned by the judge, the complainant said he was looking for 4 things: that the commission find a violation for the disconnection, but as explained previously, there's no evidence to support such a finding. Number 2, that billing be corrected. But as staff witness Fontaine even confirmed on cross-examination, no billing errors have been found. Number 3, that services be connected without payment. And this clearly also indicates that he continues to stay at the property and still does not wish to pay his bill. So the 4th item is to set up a payment agreement. That's right, asking for yet another payment agreement that's not contemplated or at least required by a commission rule, order, or company tariff. So in conclusion, no violation has occurred. The evidence has shown that. And any restarting of service at the property for complainant should only be upon payment of the required amount, which Ms. Krishmar described as 80% of the outstanding balance. Thank you very much.
Thank you, Ms. Grubbs. Any closing argument on behalf of staff?
Yeah, Judge, very briefly, I don't want to take too long with this one. I'm not going to. But as you recall, last Friday, I said then that most of the alleged issues in this case weren't really issues, and there were just a couple primary issues that you and the commission and really the parties need to concern themselves with. I think the last 2 business days has proven me right. Most of the issues, and when I say issues, I'm referring to the 1, 2, 3, 4, 5, 6, 7 items that you listed Friday morning at the very beginning of this hearing. Most of them are clearly red herrings. The few that are not red herrings are also clearly not supported by any evidence or really contested strongly. The case comes down, in my opinion, to really the questions surrounding the payment agreement or pending payment agreement or whatever it was. And there's several things that are a little bit fishy about that whole issue, I think. Number one, Mr. Felber didn't mention it, the date issue on the payment agreement in regard to his informal complaint. This, as Ms. Grubbs mentioned in her closing, that agreement didn't materialize in this docket until sometime in June. The complaint was filed in May, yet the agreement didn't show up till middle or late June. And then the phone calls. You have the phone call on May 18th that we listened to previously. You have the phone call that we heard that was also stated that the payment was due by the end of that day, the day of the phone call. So then the question becomes, I suppose, what was the day of the phone call? But Ms. Kretschmer stated that their phone system timestamps or date stamps the phone calls, and that call was on May 18th. So I don't think that's really to me, that's not, question's not what date was that phone call made. But then how did Mr. Felber wind up with the agreement that says the down payment's due on the 22nd? Not due until the 22nd. Well, we don't know. Ms. Kretschmer testified that, in her opinion, if the agreement was altered, maybe it was. But staff can't say that for definitely that it was. And for that reason, we kind of ducked that question in the staff report and tried to lay out facts on both sides of the equation, on Mr. Felber's side and on the Ameren side, that set out the positions of both parties and leave it up to the commission as the fact finder to decide. But as Ms. Grubbs mentioned, similar things have occurred on Mr. Felber's account before, which raises a bit of suspicion. But I really think if you can get it down to the questions surrounding the payment agreement, that will resolve the case one way or the other. And appreciate your patience throughout this proceeding. Thank you, Judge.
Thank you, Mr. Keegan. All right. And there are no other parties here, so there's no necessity to go further that direction. All right. Ms. Hefner, when are transcripts going to be available?
Can I go off the record while we have this discussion?
Yes.
Thank you.
Go off the record.
I cannot speak for the reporter that you had left.
On the record?
Yes, sir.
Okay. Off the record, we had discussion of when transcripts are going to be available. Ms. Hefner indicated that she thought they might be available by next Wednesday. The commission is not expediting the transcript. Under our current contract, I believe we have a 10-day turnaround. So Wednesday at the earliest, 10 days at the latest. Are there any other matters which, as I indicated, there are several motions out there that I will be taking with this case. Are there any other matters that need to be addressed by the commission before we adjourn this hearing?
No, not aware of.
I hear about 4 different voices. It sounds like most of them are saying no, but I'll just go through one at a time. Mr. Felber.
Yes, Your Honor.
Any matters that need to be addressed by the commission today before we adjourn?
I would just hope you guys would reconsider the motion.
Okay, I said I'd take the motion with the case, so I'm not going to give you any kind of immediate ruling at this point. Any matters that need to be addressed by the commission before we adjourn from Ameren, Missouri?
No, Your Honor.
Thank you. Any matters that need to be addressed before we adjourn from staff?
No, Judge.
Okay. I would like to thank everybody for showing up. Everybody was very prepared. All the parties did an excellent job of presenting their various cases. And I thought overall everybody conducted themselves very well. So it has been a fascinating and interesting proceeding for me. I can't tell you the exact date that the commission will render a written decision in this matter. Normally what transpires is there is a recommended report and order, and that recommended report and order goes out to the parties for comments. And the parties have usually 10 days to comment before it comes back. And then the commission will issue a final order. That is it. With that, I will adjourn this proceeding. And again, thank you all for your time.
Thank you, Your Honor.
And we'll go off the